Oído, a mí I would not see it.
Yes.
May I please, Lordship? Lordship, I beg to mention item number 2. Item number 2, I'm for the study respondent. I'm yet to receive an instruction. So I may be allowed to obtain instruction for
Item
3
number,
weeks.
Lordship, the respondent has been taking time for 7-8 times now.
Yes.
And this is a prayer
So
for
you
grant
are,
of disability pension, Lordship.
you file your affidavit this time.
If Lordship grants time, let it be for 2 weeks and let it be the last chance, Lord.
Heard Mr. I. Pok Pongnel, learned counsel for the petitioner. Also heard Mr. Interim in Song, learned.
Study respondent.
You are additionally,
Lordship.
learned additionally appearing for state respondent who prays for 3 weeks time for filing his affidavit in opposition. Learned counsel for the petitioner objected to the same prayer on the ground that on several occasions adjournment have been taken by the state respondent for filing the affidavit in opposition. Stop. Considering the submissions made by learned counsel as well as facts of this case, one last chance is granted to the petitioner. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Oblige, Lord.
May I please, Lordship? My Lord, I beg to mention item number 14. On behalf of Moa Engine, my Lord. I'm kindly allowed 3 weeks time to file affidavit, my Lord.
For the heard Mr. M. Veros, learned counsel for the petitioner. Also heard Mr. E. Thibafon, who submitting on behalf of Mr. Moa Chen, learned senior government counsel, praying for
3 weeks time to file
3
affidavit.
weeks time for filing affidavit in opposition. The prayer is not objected to by the counsel for the petitioner, hence same is allowed. Let this matter be listed after 3 weeks.
Much obliged.
There's an interim, Lordship.
The interim order shall continue.
Much obliged.
Much obliged.
Lordship, I beg to mention item number 6, Your Lordship. On a consensus prayer, Lordship, if this matter can come up on 28th of April, Your Lordship. Item 6.
Mr. M. Vero, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Mr. E. Thibafom, learned public prosecutor, does not oppose
No
the
objection.
prayer. Hence, the same is allowed. Let this matter be listed on
28th.
28th of April.
Much obliged, Lordship.
Much obliged.
Lordship, I beg to mention item number 19. Matter relates to the appointment of arbitrator. Certain instruction has been issued by the Chief Justice, Lordship. So I may be allowed to go through the records, Lordship, with regard to the instruction issued by the Chief Justice.
What in
This is in the record, Lordship, in the record itself. So I have not gone through the records. So if this may
Not
be listed on
necessary.
Friday.
Younger Vati, learned central government council, who prays for
Which time? On Friday, Lordship.
weeks time to go through the case record.
Yes, Lordship.
The prayer is allowed. Let this matter be listed after a week.
My Lord. Much obliged.
Privileged Lordship. My Lord, I beg to mention item number 24.
Yes.
I'm for the respondent number 4 hearing. My Lord, if this matter may come up on 8th of April, I have taken the consent of the opposite parties.
Heard Mr. Takakichu, learned counsel for respondent number. You are for respondent number?
For my lord,
Respondent number 4. Who prays for how much?
on 8th of April.
Who prays for listing this matter on 8th of April. Also heard Miss
And solo for the petitioner.
and solo for the petitioner as well as Miss S. Mary for the state respondent who you are also appearing.
Correspondent number 5, I just.
Mr. I. Jamir for respondent number 5. Who do not opposes the prayer for the prayer of learned counsel for respondent number 4. As the same is allowed. Let this matter be listed on
8th of April.
8th of April.
Much obliged.
Much obliged.
May I please, your lordship. Lordship, item number 1, on behalf of A. Ayumi, kindly grant 3 weeks of time to file affidavit.
Heard Mr. Supangwati Waling, learned counsel for the petitioner. Also heard Mr. What is your name?
Ajungli, lordship. Ajungli,
Anjungi,
lordship,
learned counsel appearing, learned government counsel
behalf of A. Ayumi,
appearing on behalf of Mr. A. Mijumi,
Ayumi.
who prays for 3 weeks time
Lordship,
for
lordship.
filing affidavit in opposition. The prayer is allowed, list accordingly.
Lordship, similar prayer on behalf of S. Shang, item number 3, lordship. Here she is yet to receive instruction, so kindly grant 3 weeks of time.
Same order on behalf of S. Chang. 3 weeks time granted.
Lordship, apply. Lordship, item number 5, it's mine, lordship. Lordship, here I'm yet to receive instruction, so kindly grant me 3 weeks of time. No, lordship, 7, item number 7.
Who is for the petitioner?
7.
Heard Mr.
Ajungli,
Anjungli, you have no objection.
No objection.
Also heard Miss, what is it? Ayala Imchin, learned counsel for the petitioner. Learned government counsel prays for 3 weeks time for filing
3 weeks, lordship.
affidavit in opposition, to which learned counsel for the petitioner does not oppose. Hence the prayer is allowed. Let this matter be listed after 3 weeks.
Lordship, item number 8, S. Chang, here she is preparing her affidavit, lordship. So kindly grant 3 weeks to file affidavit under preparation. Item number 8,
No objection, your lordship.
What's your name?
Rosemary Kikon.
Rosemary Kikon. Same order, 3 weeks time.
I'll oblige.
May I please, lordship. Lordship, I would like to mention item number 5. Here, I would like to file an affidavit in reply. So 3 weeks time may be granted to file affidavit in reply.
Heard Mr. Aring Long, learned counsel for the petitioner. Also heard Ms. Ajungli, learned government counsel. Learned counsel for the petitioner seeks 3 weeks time to file reply to the affidavit in opposition filed by the state respondent. Prayer is allowed, list accordingly.
Much obliged.
May I please, your lordship? Lordship, I'm appearing through VC, lordship. Lordship, I'd like to mention orders item number 11, lordship. Lordship, here in this case, lordship, service is awaited upon respondent number 2 and 3, lordship, the owner and the driver, lordship.
You are for?
I'm for the appellant, lordship.
For heard Mr. V. Devnath, learned counsel for the appellant / applicant. Also heard Mr.
MT Wapang.
MT Wapang, appearing for respondent number 1.
Wow.
It appears that the notices issued to respondent number 2 and 3 have not yet returned. Await further. List this matter after 2 weeks.
Obliged.
Right, lordship.
No, please, lordship. The lordship, I'd like to mention hearing number 2223. Kindly this matter may be listed after 2 weeks.
It is listed with 21 also. Oh, no. Yes, 21, 22, 23 are tagged.
Yes, your lordship. 20 to 23.
Who is for 21?
Your lordship, same parties.
So you are mentioning for 21, 22, 23.
20, 21, 22, and 23.
Okay, 20 to 23.
Yes, your lordship.
Heard, Miss, what is your name?
Ali Dosu.
Alito Su, learned counsel for the respondent number.
For all the respondents.
For the respondent, also heard Mr. M. Vero,
For applicant.
learned counsel for the appellant. What is your prayer?
Your lordship, the senior counsel is indisposed.
Learned counsel for the respondents prays for an adjournment on the ground that the conducting counsel for the respondent is indisposed. The prayer is not objected to by the counsel for the appellant, hence same is allowed. Let this matter be listed after 2 weeks.
Much obliged.
Your lordship, I have a similar prayer for item number 4. Your lordship, here we are yet to file our affidavit in reply, so kindly grant us 3 weeks' time to file our reply.
Heard Miss Alito Su, learned counsel for the petitioner. Also heard Mr.
Lordship, I'm for private respondent number 5.
What is your name?
Single.
Singlo, appearing for private respondent number 5, as well as Mr. E. Tiba from learned government counsels, appearing for state respondent. Learned counsel for the petitioner has prayed for 2 weeks' time for filing reply to the affidavit in opposition filed by the state respondent
And private respondents.
and as well as the private respondent. The prayer is allowed. Let this matter be listed after
2 weeks.
3 weeks.
Your lordship, there is an interim.
The interim order shall continue till next day.
Lordship, we're back to mention item number 29 in admission, Lordship. Lordship, this matter was taken up on Friday, 21st March, Lordship. And as with the last order, Lordship, I was directed to file an affidavit pertaining to that Zima
Item number 29.
29, Lordship, on the
Yes.
supplementary list, Lordship.
Yes.
Lordship, I find the affidavit this morning if the affidavit may be called for, Lordship.
Okay. That RC,
Yes, Lordship, RC. I have enclosed the RC in the affidavit, Lordship.
yes, call for the affidavit in item number 29.
Obliged, sir.
May I please, your lordship, I beg to mention item number 18 on behalf of respondent number 5.
Yes, what is your prayer?
Due to personal difficulties, my senior is not here.
Lordship, if the matter may be fixed for
On?
3rd April.
Okay. Heard, Miss. What is your name?
YP Gupta, on behalf of YA.
What is your name?
YA Kunyak, on behalf of
YA Konyak, learned counsel, appearing for Mr. YP Gupta, learned counsel for the respondent. Also heard Miss
It's solo for the petition.
El Solo for the petitioner, as well as Mr. E. Tiba Form, appearing for respondent number 1, 2, 4. Learned counsel for the respondent number 5, prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. The prayer is not objected to by the counsel for the petitioner as well as state respondent. Hence, same is allowed. Let this matter be listed on 3rd of April.
May I please, your lordship, I pray for your indulgence in item 24. Your lordship, there is an interim in the matter.
In item number 24, interim shall continue.
Much obliged.
Please, my lord, lordship, item number 17, lordship. Lordship, I've overlooked the costly studio, so I could not prepare the case. So, my lord, can you
Otherwise,
accommodate?
I've been waiting very patiently for my lord's bench.
Heard Mr. Senti Yange, learned counsel for the petitioner. Also heard Mr. KV Angami, learned public prosecutor, who prays for an adjournment on the ground that he could not go through the records and needs some time for preparation. Considering the ground, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
After 3 weeks.
After 3 weeks or on a date to be fixed by the minister.
Lordship,
Or
is there a possibility to be taken up tomorrow or Thursday, Friday?
He's seeking 3 weeks time.
Lordship, if possible, tomorrow also fine, but.
Tomorrow.
Yes, if my lord can accommodate.
What is the matter?
It's a regarding theft, Lordship.
Okay, tomorrow.
Our lordship.
My lord. Sentence is for 1 year, 3 years. He has already served, 3 months he has already
Let this
served before
matter be
availing bail.
listed tomorrow. That is on 25th of March.
Lordship. Lordship.
Deeply obliged.
Thank you, Lordship. I'd like to mention hearing item number 25. I senior personal difficulties today. I pray that this matter may be listed on Thursday, that is 27th of March.
Not Thursday will be difficulty.
Lordship.
It has to be next week. You,
Lordship, tomorrow?
not tomorrow. Thursday you have difficulty. You suggested it. Suggested it.
Lordship, the respondent number 2 is.
Performer respondent. It's between the private respondent and the petitioner.
Okay, you suggested it. When do you want?
Lordship, on Friday?
No, not Friday. Let it be on in the next week only. Heard miss.
Lordship, tomorrow then.
What is the matter?
Lordship, is a matter between, land dispute between the private respondent and the.
Next week. Heard miss. What is your name?
Lordship, if the matter may be listed tomorrow then. It's a short matter.
Okay. Rizo Kera. Lanet.
Menoshino.
What is your name?
Menoshino.
Menoshino, Lanet Counsel for the respondent. Also heard Mr. What is your name?
Nansangaya.
Mansang Iyer, Lanet Counsel for the petitioner, as well as Mr. K.V. Angami, Lanet Public Prosecutor. Lanet Counsel for the private respondent prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed tomorrow, that is on 25th of March.
Lordship, interim order may be.
The interim order shall continue till next day.
For motion from the supplementary cost list, item number 26.
So Lordship, this present contempt petition is being filed to initiate contempt proceedings against the respondents for willful and deliberate disobedience of this Honorable High Court's order dated.
You are not audible. Speak loudly. Okay, what is your name?
ILMG.
Heard Miss Ayla Imchen, Lanet Counsel for the petitioner. This application under section 11/11 and 12 of the Contempt of Courts Act, read with Contempt of Courts within bracket Gauhati High Court Rules 1977, as well as Article 215 of the Constitution of India, filed by the petitioners alleging willful disobedience of this court's order dated 14/11/2024, passed in writ petition within bracket C number 133/2022 by the respondents. Stop. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by registered post with ID as well as by usual mode within a week from the date of this order, returnable after 4 weeks. List accordingly.
For motion from the supplementary cost list, item number 27.
May I please, Lordship. My lord, the petitioner before his court is seeking an interim custody of his vehicle which was seized on 5/10/2024 by the police personnel. And that has been kept in the police custody unattended for the last.
Where is the rejection order? Why it was rejected by the trial court?
Lordship, I'll take Lordship, page 22, start from page 22. The relevant page rejection for is page, paragraph 9, page 24. May I read it, my lord? Paragraph 9. Paragraph.
Yes.
That the accused slash petitioner being the owner slash driver of the seized vehicle, as well as the owner of the seized article drugs. In the instant case, this court is not inclined to release the seized vehicle, the vehicle documents to the petitioner slash accused at this stage. The report of the IO also states that requisition of the seized vehicle has been sent to RTO Senapati and the report is still awaited. This is the ground, saying that.
You are all accused.
Yes, I'm an accused.
Then you have deliberately used this vehicle. How will you get this way?
My lord, that whether I'm really carrying the seized drug or not, that will come out only at the time of trial. I'm completely denying that nothing was recovered from my vehicle.
No, but prima facie it appears that.
My only, at this stage, Lordship is aware, my only prayer is that just interim custody, because it has been, no good purpose will be served if vehicles kept unattended for a year outside the police station. So therefore.
You show me the authority where the vehicle may be granted Jimma to the accused.
My lord, I'll just show one judgment from this High Court, Hon'ble High Court, Gauhati. It's paragraph 2. This is from our own Gauhati High Court, paragraph 2, my lord. Paragraph 2. The petitioner is the prime accused in this case, and he has prayed for Zimma of the vehicle bearing registration number so-and-so, a motorcycle TVS so-and-so. Earlier, his prayer of Zimma of the vehicle was rejected, while order 21/9/23 passed by the learned special judge Tubri in connection with special case number so-and-so arising out of so-and-so and so-and-so. So now the bail was, the Zimma was rejected by the trial court. Now Lordship will see the finding of this noble court. Lordship, let's start from here. No? I'll start reading from paragraph 2, 3. I'll just do, my lord, paragraph 3. I'll start from short order on this. The petitioner has challenged the legality and propriety of the order dated 21/9/23 in special case number so-and-so. The order is reproduced here in below. Accused Dr. Ali is absent without any stamp. Summon issued to accused person is returned after proper service. Issue BWN number 2. My lord, I'll just come to paragraph 4. It is submitted that no reasons were assigned by the learned trial court while rejecting the petition right order number 21/9/23. The petitioner has also relied on the decisions of this court in Union of India versus Tejinder Singh in connection with criminal case number so-and-so, right? Order dated 2/3/23, wherein it is observed that court, para 20, in cases of Rabir Singh, Elijah Bira versus the Punjab, so these are the difference. My lord, I'll next page. Paragraph reproduction only, paragraph 22. Now, the question that arises for determinations of the section 451 CRPC can be applied while considering the plea of interim for interim custody of the vehicle, seized vehicle under.
Yes, Miss Mary, what is your submission?
Allowed to hand over to CD.
CD is there?
Yes, Your Lordship. On the earlier occasion, the petitioner has filed a clinical revision which has been withdrawn. Whereas in that case, time was given to the state to obtain CD, so CD has come. And this can be used for the instant case CD.
Okay.
So even in this case, in the
Your
case.
Yes, No, yes.
Your lordship, here, the accused himself is the vehicle owner. So now the factor, whether the vehicle has been used with intention or not, that has to be shown. That has to be shown, your lordship. Here, your lordship, the petitioner, the accused is on default bail. That does not mean that it has given a right to the petitioner to be granted an
Can you find
interim
some
custody.
authority where the prayer for Jimma was rejected when the Jimma is sought for by the
That
accused?
I will need some time, your lordship.
Take time.
Because, yes, your lordship.
Let her find out.
Thursday, your lordship.
Okay.
Can it be on Friday next month, Friday? Thursday, I might have some difficulties.
Then let it be in the next week,
Or Thursday, no, but Thursday,
next week.
Thursday. I have a plan to go to Pan, but
Okay. Heard Mr. Azo, learned counsel for the petitioner. Also heard Miss S. Mary, learned public prosecutor. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated order dated 30/1/2025, passed by the Court of Learned Special Judge NDPS Kohima in IA number 406/2024, whereby the prayer for grant of Jimma of the seized vehicle was rejected by the trial court. Stop. Learned public prosecutor Ms. S. Mary has produced the copy of case diary of Kohima PS case number 6, PS case number 43/2024, which was available with the Office of the Public Prosecutor. However, she has prayed for some time to produce some authority, to bring some authority in support of her objection to the prayer for grant of Jimma to the petitioner. The prayer is allowed. Let this matter be listed again on
Thursday.
Thursdays. Then on 27th of March. 27th of March.
March of.
The copy of the case diary, we'll keep it here.
For motion from the supplementary court list, item number 28.
May I please, Your Lordship? My lord, I have sent copy to the opposite parties. And the applicants herein are the necessary parties. So, my lord, the applicants are praying for impleadment.
You have objection,
Yes, your lordship. Can you grant us 4 weeks to file our objection?
Ms. Livika? You have objection.
Lordship, seeking instruction alone.
Okay. Heard Mr. M.
Imkong Jamir.
M. Imkong Jamir, learned counsel for the petitioner. Also heard Miss
And solo appearing.
N. Solo appearing for
Mr.
which
Respondent for your lordship.
respondent number 4, as well as Miss Livika appearing for state respondents, state respondent. This application has been filed by the applicant under order 1, Rule 10 of the CPC for impleading the applicants as respondent number 4, 5, and 6 in writ petition number 63K/2021. Learned Government Counsel Ms. Livika seeks some time for seeking necessary instructions in this regard. Whereas Learned Counsel for the respondent number 4, respondent number
For
4 seeks 3 weeks time
time.
4 weeks time for filing objection to the prayer. The prayer is allowed. Let this matter be listed after 4 weeks.
For admission, item number 9.
I have no objections, Lordship.
Heard Mr. Fenty Younger, learned counsel for the petitioner. Also heard Mr. Muaz Zamir, learned counsel for respondent number.
Sole
The sole respondent who seeks 2 weeks time for filing affidavit in opposition. The learned counsel for the petitioner does not oppose the prayer. Hence same is allowed. Let this matter be listed after 2 weeks.
Lordship, there is an interim.
The interim order shall continue till next day.
Much obliged.
For admission from the supplementary course list, item number 29.
So I filed the affidavit this morning. Sir.
Where is the registration certificate?
Lordship, may kindly come to page number 7, Lordship. The last page of it.
What is the date of registration? Is 22/12/2006.
Okay.
What was the date mentioned in the DTO report?
It was in the year 2023, Lordship, December 2023. Lordship, if your Lordship may kindly appreciate, it expired in that same year, Lordship. If your Lordship may kindly come to the second bottom of the registration certificate, Lordship. Registration up to 21st December 2023.
Oh, yes.
So it expired on that day, Lordship, 21st December 2023. So apparently, Lordship, that was the renewal, Lordship. The learned PP has relied upon the document. It was on the renewal date, Lordship, not the fresh registration because.
Yes, Ms. Lee.
Yes, Your Lordship, now my question will be, Your Lordship. The renewal is from 2023. The sale has been executed on March 2023. Now, whether the person who has already given all the title, all the documents, everything to the purchaser, to the person who has owned it, Your Lordship, whether that person can come before under the MVA can go and register in the name of the person who has sold it. Is it possible, Your Lordship?
No, what is?
It has been renewed in the person's name only, Your Lordship. The sale was executed on March 2023.
Because the new purchaser has not done the formalities.
Lordship, yes.
Now how, Your Lordship?
stated in
Now
my
you have to
petition,
go to the MV Act, Your Lordship. How that is done, Your Lordship? We have to go as per the Act, Your Lordship. We have to see what the Act says. Once, how does the ownership of transfer is to be taken, Your Lordship? We have to go to the MV Act. And Your Lordship, since I received the affidavit this morning only, it draws from the form, Your Lordship. You can see from section 48, 47, how new registration can be done. 48, no objection certificate has to be obtained. How everything 50, how transfer can be done. Everything is there. There's a limit, Your Lordship, time limit. Now, whether they have done that or not, Your Lordship. I'm questioning, Your Lordship, the authenticity of the ownership of the petition. That's it, Your Lordship.
For a moment, Lordship, with due respect, Lordship.
this proceeding
What is the procedure
Your
of
Lordship,
trans?
that's why, Your Lordship, since I also received the affidavit this morning, Your Lordship, I just downloaded it from my phone and like I was just browsing it on it. Your Lordship, this is the procedure, Your Lordship. So a copy, like, I can also give
Copy
you
of
sometime, yeah, yeah.
this affidavit.
No, copy to, I've already received the MVA, Your Lordship, so that we can.
You want some time
Yes.
to go.
Yes, Your Lordship.
We'll fix
Otherwise,
it.
Lordship, I kindly appreciate that this is not a proceeding under MV Act.
No, it's not a
No,
proceeding, Your
let,
Lordship.
let her prepare. We'll fix it tomorrow, day after tomorrow.
Tomorrow, Your Lordship.
Heard Mr. Moa.
Your Lordship, the reason why I'm objecting, like, there's a discrepancies is because, Your Lordship, here, the accused has said that, like, the real owner is another person, Your Lordship. And here, the petition is coming, his owner. That's why, Your Lordship, I'm finding an even in the
very
obtaining
simple,
of
Lordship.
documents.
No,
Lordship.
I have respectfully submitted before this local court that the registered owner is Mr. Manoj Kumar. I admit to that fact, Lordship. But Lordship.
But let her assist the court properly.
Yes, Your Lordship.
Because
To the court, Your Lordship.
Manoj Kumar had an agreement to sell the vehicle to some other person.
It's already sold, Lordship. It's already
the
sold.
not to the petitioner.
And it is
There are-
already, no objection has,
No
certificate has already
objection.
been issued against one person.
Against the third person.
And that is as per the provision
So
of MVA.
let us see what is the provision of MV Act and what is your answer to that. When provisions of MV Act are not followed, then whether the custody of the vehicle can be given on the basis of a sale deed. These questions are to be answered.
Otherwise, the sale deed is already registered, Lordship. And statement has also been
Okay,
recorded
we'll
by
take it tomorrow.
Yes, Your Lordship, we will
Heard-
just, let's see, it's up to the court, Your Lordship.
Okay, heard Mr. Moazamir, learned counsel for the petitioner, also heard Ms. Livika, learned public prosecutor. Learned counsel for the petitioner has filed an additional affidavit bringing on record the copy of the registration certificate of the vehicle in question. Learned public prosecutor has sought some time to make her submissions regarding the question as to whether without registration of the vehicle as per the provisions of MV Act, the present petitioner can be regarded as the owner of the vehicle of which Jimma has been sought for by him. The prayer is allowed. Let this matter be listed tomorrow. That is on 25th of March, 2024.
For admission from the supplementary course list, item number 30.
But that's Your Lordship.
Who is for the petitioner? Makindri Chapo. Today was the date for appearance.
Yes, it is fixed for, yes. Distributor bill is still today, Your Lordship.
No,
There's an interim.
petitioner is absent. We'll take it up after some time. He may come. Or what is your suggestion?
Your Lordship, since the city has arrived and as far as the question of notice is concerned, Your Lordship, no notice has been issued, Your Lordship. Since the reason why the city was recalled was because of the notice, Your Lordship. So as far as that is concerned, Your Lordship, it's admitted that like no notice has been issued. Your Lordship, city.
Have you appeared
Yes, my lord, yes.
today? Before.
On 21st, you have appeared before the.
When was the date for appearance? Fixing 21. Today is 24. You appeared on 21st.
Yes, my lord. Please order.
Now, what is your submission?
Now, your lordship, as now lordship, since the interim has been granted, your lordship. And as far as the notice code that your lordship is admitted by an IO, your lordship. The thing is that he seems to be a person who has purchased, your lordship,
Who has?
purchased the scooter, the bike here.
Okay.
So your lordship, I will leave it to the wisdom of this court.
No, but the question in this case is, he was not available before the IO.
Yes, your lordship.
Therefore, warrant was issued.
Yes, your lordship.
Now directions are issued to cooperate in the investigation.
Yes, your lordship.
Now your purpose is solved.
Yes, your lordship.
Served. Mr. Pakinvi Chapu, learned counsel for the petitioner. Also heard Ms. Livika, learned public prosecutor, who has produced the case diary of which police station? Of Kohima North PS case number 39/2024. Stop. Learned counsel for the petitioner has submitted that. No, Mr. Pakinri Chapo, learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court by order dated 23/2025 with a direction to appear before the Court of Learned Chief Judicial Magistrate Kohima on 21st of March 2025. And in pursuant to the directions of this court, the petitioner has appeared before the said court. And you have appeared before the IO also.
You appeared before the CGF, if I'm not mistaken.
No, but you have to cooperate in the investigation.
Yes, madam.
You have to appear before the IO now.
Yes, madam. It's when called by the IO.
No, you appear, we are issuing a direction. You appear before within 7 days. Within 7 days.
Yes, madam.
Stop. What was the last line?
And then also for the petition, the submitted that the petition was granted interim bail by this court by order dated 20th March 2025 with the direction to appear before the court on
Appear before the Court of Learned Chief Judicial Magistrate Kohima on.
the direction of this court, the petitioner has appeared before the said court.
Stop. Stop. Means the petitioner has complied with the directions of this court. And is ready to cooperate in the investigation. This anticipatory bail. No, the interim anticipatory bail granted to him by order dated 23/2025 is hereby made absolute with a direction to the petitioner to appear before the investigating officer of Kohima North PS case number 39/2023 within a period of 7 days from the date of this order and cooperate in the investigation. With above observation, this anticipatory bail application is disposed of. Send back the case diary. Yes.
Is there can there be an observation that in the event petitioner doesn't cooperate, you know, and at least some provision so that the higher can take steps in the event?
He shall comply. No, before disposing of, he shall comply with the conditions. Condition number 1 and 2 mentioned in the order dated 23/2025. Stop. Any violation of the said condition shall be good ground for cancellation of anticipatory bail granted to him. This much will do. This anticipatory bail is accordingly disposed of. Send back the case diary.
For orders, item number 10.
Your Lordship. Your Lordship, I'm back on behalf of PP Chetri for the appellant Lordship. Your Lordship, as per the office that noted dated 24/1/05, notice to respondent number 3 has returned answer, Lordship. So if your Lordship can give some time to take fresh steps.
Heard, Mr.
Lordship, I'm appearing for the first time for the respondent before, Your Lordship, or from our respondent.
Chupa, Lordship.
Notice to
Respondent number 3, Lordship.
3 has returned.
Yes, Lord.
Heard, Mr. What is your name?
Chupa, Lord.
Chupa,
Chupa Pongan, Lordship.
learned counsel for the appellant. Also heard Mr.
On behalf of
M. Vero, learned counsel appearing for respondent number 4. On the office note dated 28/2/2005 indicates that the notice issued to respondent number 1 and 3 have not yet returned.
Return is returned.
Only the respondent number 3.
Only the respondent number 3.
Which office note dated?
24/1/025. 24/1/25, Lordship.
Okay, notice. You have not issued fresh notice. Notice issued to respondent number 3 has returned with remarks returned to sender.
Lordship.
Stop. In view of the above, the petitioner is directed to take fresh steps for issuance of notice on the respondent number 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
For orders, item number 13.
Lordship, the service upon the respondent number 2, that is the FIR informant, is still awaited by registered AD. Lordship, however, by trustee service, we have already taken steps upon him, and we will be filing the affidavit within the course of the week, Lordship.
But whether Dusty was allowed?
Yes, Lordship. Trustee was allowed.
Where is the order?
Lordship order dated 18/2/2025, Lordship.
Okay. Okay.
We are all the petitioners as well as the private respondent. We are all members of the same village, Lordship. We are.
Heard Mr. Senti Younger, learned counsel for the petitioner. Also heard Ms. Who is for the state respondent? Mr. Thiba
Yes,
Fong.
yes, Mary, yes, Mary.
Yes, Mary.
Yes, Lordship.
I'll show her presence.
My lord,
She-
my lord, my lord.
Also at Mrs. Mary, learned public prosecutor. Learned counsel for the petitioner has submitted that as directed by this court by order dated 18/2/2025, the petitioner has taken steps for issuance of notice on the respondent number 2 by Dusty mode also, and he would be filing his affidavit in compliance when
Within the course of the week.
within the course of the
My
week.
lord.
The prayer is allowed. Let this matter be listed after a week.
After 3 weeks, lordship.
After 3 weeks, the interim order shall continue till next day.
Deeply obliged, lord.
For hearing, item number 15 and 16.
Worship, I'm for the respondent. So, I may be allowed to file a gist of argument by 27th of this month.
Gist of argument.
Yes.
Written.
Written. Because, I have some, pre-COVID engagement, which cannot be avoided by me. So, yes.
We will not be here tonight.
No, I'll be here, but, I can upload.
Yes, Mr. Zimomi.
Gist of arguments, right?
27th, Thursday, I'll submit on that day. It's a.
I can start, madam. If he's going to be here. Subject to your lordship's convenience, what your lordship desires.
What is your submission? Now, when will you be submitting your gist of argument?
27, Thursday, it's a.
And on that day, you will be replying.
I'll submit because of paucity of time and because of the official engagement. I am in such a position to keep my verbal submission. So I may be allowed to file only the gist of argument.
In that case, I will have to reply to his gist of arguments also.
Yes.
I think it's better we fix another date then, madam.
Yes.
When he's present. So
You
that they can-
suggested it.
everything can be concluded, your lordship.
Heard Mr. A. Zimomi, learned counsel for the petitioner. Also heard Mr. Imti Song, learned additional AG, appearing for state respondent, as well as Mr. A. Zo, appearing for respondent number 4, and Mr. Takakichu. You are also okay. Respondent number 4, learned additional AG has prayed for an adjournment due to his personal difficulty. He also prays for allowing the respondent to file written gist of argument. The prayer is allowed when
Your lordship, let it be on the 22nd of April.
let this matter be listed on 22nd of April.
Your lordship, no further adjournments. No further adjournments, your lordship. This matter has been pending for a long time.
When will you be filing?
Sure, my submission was 27th of this month.
You file with a copy to the. No.
In that case, your
no.
lordship, it will not be necessary
Yes,
because we will have a full hearing on it.
Yes, that is a case. I don't need to file. Yes.
No, you can still file on the next date fix. Because you still don't know what will be his argument. He has not yet argued his case.
Your lordship, my problem is.
We are allowing the adjournment, fixing it on 22nd of April.
Yes, my lord. No further adjournments, madam.
No other observations.
Yes, not. Much obliged, madam.
For hearing from the supplementary cost list, item number 31 to 33.
Yes, Mr.
My lord, petitioner counsel is coming.
What should we do? Should we wait? You're ready? Otherwise.
I'm ready.
He's on legs in undercoat. What is the matter?
My lord, the petitioner, they're seeking for extraordinary pension money.
Extraordinary pension?
Yes, my lord. The petitioner's husband was serving as a lineman in the power department. They died while performing official duty. And on that ground, they asked me for extraordinary pension.
Otherwise, they are not getting the pension.
Yes, yes, they were in work charge.
Work charge.
Yes, they were electrical.
What is your submission? What will be your stand?
My lord, my stand will be, since the petitioner service has not been regularized, so they are not entitled
to get pension.
Yes. For the AG lordship. As far as my part is concerned,
AG.
AG is not, no. And unless the
Government.
state agrees, then we will be there to process the pension. So I have no role as such.
Okay. What are the rules?
My lord,
Or we take up the next item. Wow. Call next item.
For hearing from the supplementary cost list, item number 34.
34, Mr. Jamir, you are there. What is the, you are ready?
Lordship, yes, Lordship.
What is the matter?
Lordship, in this case, Lordship, I'm challenging the appointment of the private respondent, Lordship. The private respondent was appointed to a grade 4 post, Lordship. I'm aggrieved by that, Lordship. On the several grounds, Lordship. The firstly, on the ground that there's a notification in the state of Nagaland, which says that an appointment for a particular district, it has to be from an indigenous inhabitant of that particular district, Lordship.
Who is for the private respondent? You are for.
Also, basically, this matter, the petitioner has filed a writ petition challenging my appointment, but my appointment order has not been impugned.
Not impugned.
Lordship, I have impugned, Lordship.
No, Lordship. Only the administrative approval. So
Okay.
whether without the challenge to the appointment order, whether this court can interfere with the appointment order and the submission of the petitioner on the ground that the indigenous inhabitant. No, Lordship, the post is not meant for Woka district. It's under Nagaland.
Okay, let us hear.
NCC, now National Cadet Corps.
Let us hear the matter. Yes.
If the Lordship may kindly allow me to take the Lordship to the impugn the Lordship.
Impugned?
Appointment order, Lordship, notification. Page number 70, Lordship. Page number 70.
17.
17, Lordship. 17. Lordship. Lordship will find the type copy at page number 18. 18. If your Lordship got it.
It is an office memorandum. 18.
18 is the notification, Lordship.
Just Oh, this is the affidavit. Yes.
18, Lordship. This is dated 16 January 2023, Lordship. May I read this order, Lordship?
Yes.
Consequent upon the approval of government-wide letter number so-and-so, dated 13/01/2023, the undermentioned is hereby appointed as grade 4 in the establishment of OC 24 so-and-so NCC Kohima under the Department of Youth Resources and Sports, Nagaland, Kohima, in the pay level 1 of the pay matrix plus all other allowances as are admissible under the rules in force from time to time with effect from the date of taking overcharged. So it is the name of the private respondent number 3, Lordship, and the PIMS code of retired employee against which vacancy appointed is made so and so. The appointee shall be on the probation of 2 years. On completion of the probation period, he or she shall be for service conformity, subject to fulfillment of the conditions prescribed in the service rules. He or she shall be liable to be discharged from service if he or she fails to fulfill the required conditions as laid down from time to time during the period of probation. Other conditions of service not stipulated in this notification shall be governed by the relevant rules, orders issued from time to time. The appointment order is subject to subsequent confirmation of service on the recommendation of a medical board and verification of antecedents. In case of false declaration, submission of wrong information, the appointment shall be revoked and other criminal proceeding, legal action shall be initiated. That is the notification, Lordship.
This is the appointment order.
Yes, Lordship.
This you have impugned.
Yes, Lordship. Lordship, may kindly come to page 12, Lordship.
Yes. Yes.
Prayer number 1, Lordship. Question set aside the impugn not appointment white order number so and so dated 16/1/2023. This is the same date, Lordship, whereby the private respondent number 3 was appointed, Lordship. In respect of respondent number 3, issued by the Director, Youth Resources and Sports, Kohima. Respondent number 2 being illegal, Lordship. My second prayer is to direct the state respondents to consider case of the petitioner for appointment to the post of NCC Laskar. What has happened, Lordship? There was a vacant post in the year 2023, the post of Laskar, Lordship, and which was subsequently redesignated as MTS, multi-tasking staff, Lordship. This is a grade 4 post, Lordship. So I have category mentioned in the petition that the post was attached to the school, Lordship, under Walker District, Lordship. Yes, I agree that this post comes under the Department of Youth Resources and Sport, Lordship. However, the employee who retired, Lordship, he was attached to Government Higher Secondary School, Walker, Lordship.
Okay.
I'll limit my facts, Lordship. That is the simple basic facts, Lordship, in a nutshell, Lordship. Against that vacant post, I have submitted my application, Lordship. And altogether, it appears from the affidavits filed by the government, it appears that altogether 81 applicants have submitted for the against such post, Lordship. 81.
Against the single post?
Yes, Lordship. 81 applicants were there. And it appears that there was district selection. Of any government departments or any establishment, Lordship, they acquired a land. And on basing on such donation of land, they enter into agreement, maybe for any other considerations, some for employment, some to avail some contracts, workers and all, Lordship. That is the system, Lordship. And in the welter of decisions by this Honorable Court, Lordship, such agreements are being considered. And basing on such agreements, directions are also issued to the respondent authorities, to the state authorities to make appointments, Lordship. But that is not my case in this present read petition, Lordship. But I have made a categorical statement that my ancestors, they have donated a plot of land in the year 1964, Lordship. That is the first contention. Second, Lordship, which I'm also not pressing at this stage, Lordship. Second is that I have also raised a contention that appointment, if it has to be made, it has to be from the, at least one amongst the indigenous inhabitant of that particular district, which is the Wakha district, Lordship, in the instant case. Even the second contention, Lordship, I'm not pressing in this present read proceeding, Lordship. Yes, no doubt I have raised those contentions when the petition was filed. Third, Lordship, my only ground, Lordship, is that there was no advertisement. There was no advertisement. I was aware of the vacant post, Lordship, no doubt. I was aware of the vacant post. I have submitted my application. I have submitted my application, Lordship.
Okay.
But the constitutional mandate, Lordship, as far as appointment is concerned, constitutional mandate, advertisement has to be issued, Lordship. It is all the eligible candidates. And Lordship is well aware of the unemployment situation in the state of Nagaland, Lordship. There are numerous of educated unemployed youths, Lordship. And in tune with the mandate of Article 14 and 16, Lordship, advertisement has to be issued. Now the state respondents, they have also filed the affidavit stating that there was a selection committee.
When was the appointment issued?
2023, Lordship.
23.
2023.
Okay.
16/01/2023, Lordship.
Yes.
Therefore, Lordship, the appointment of the private respondent number 3, since it did not fulfill the constitutional mandate, is illegal, Lordship, and it has to be quashed and set aside. That is my respectful submission before this honorable court, Lordship. Lordship, I also consider the fact that I was aware of the vacant post. I have
You
submitted my
apply-
application.
You applied also.
Yes, I have also applied for it. I have also applied for it.
Okay.
But for all fairness, Lordship, for all fairness, advertisement has to be issued, and that selection process has to be in a fair manner, Lordship. It has to be conducted in a fair manner.
You are relying on some authority.
Yes, Lordship, I'm relying on this.
This is your main contention, that
My
the
main
appointment
contention.
was without any advertisement.
Yes, Lordship.
Therefore, it is bad.
Yes, Lordship.
Okay.
So therefore, my prayer at this stage is to question set aside and give a direction to the respondent to issue advertisement, Lordship, so as to all the eligible candidates will participate in such selection process.
You took this plea in your writ petition.
No, Lordship. No, Lordship. My submission was to question set aside and also to consider my case, Lordship. That was my prayer, Lordship. But at this stage, Lordship, after perusing the affidavits filed by the state respondents as well as the private respondents, Lordship, it appears that there was a selection committee, Lordship, constituted by the department. It also appears, Lordship, there's a notification which I have relied upon. I consider the fact that it is only pertaining to the post which comes under the district administration. I have to really admit that, Lordship. And this particular post does not fall under the district administration. Which is why, Lordship, I'm not pressing that. 2017, Lordship. May I take the Lordship to the authority which I'm relying upon, Lordship? 2011, 3 SSC 436, Lordship. 2011, Volume 3 SSC 436. Paragraph number 35 and 36, Lordship. Page 451, Lordship. Paragraph number 35.
Yes.
May I read it, Lordship?
Yes.
At one time, this court had been of the view that calling the names from employment exchange would curb to a certain extent the menace of nepotism and corruption in public employment. But later on, it came to the conclusion that some appropriate method consistent with the requirements of Article 16 should be followed. In other words, there must be a notice published in the appropriate manner, calling for applications, and all those who apply in response thereto should be considered fairly. Even if the names of candidates are requisitioned from employment exchange, in addition thereto, it is mandatory on the part of the employer to invite applications from all eligible candidates from the open market, Lordship. This is important. By advertising, Lordship, this is also important. Open market and by advertising. The vacancies in newspapers having wide circulation or by announcement in radio and television as merely calling the names from the employment exchange does not meet the requirement of the said article of the Constitution. 36. Therefore, it is a settled legal proposition that no person can be appointed even on a temporary or ad hoc basis, inviting applications from all eligible candidates. If any appointment is made by merely inviting names to the employment exchange or putting a note on the notice board, that will not meet the requirement of Articles 14 and 16 of the Constitution. Such a course violates the mandate of Article 14 and 16 of the Constitution of India, as it deprives the candidates who are eligible for the post from being considered. A person employed in violation of this provision is not entitled to any relief, including salaries. For valid and legal appointment, mandatory compliance with the said constitutional requirement is to be fulfilled. The equality clause enshrined in Article 16 requires that every such appointment be made by an open advertisement as to enable all eligible persons to compete on merit. Next, Lordship, 2014, Volume 14, SSC, page 50. 2014, 14 SSC page 50, Lordship. Paragraph 16. What we will find page number 61, the relevant paragraph 16 at page number 61.
Yes.
Another important requirement of public employment is that of transparency. Therefore, the advertisement must specify the number of posts available for selection and recruitment. The qualifications and other eligibility criteria for such posts should be explicitly provided, and the schedule of recruitment process should be published with certainty and clarity. The advertisement should also specify the rules under which the selection is to be made. And in absence of the rules, the procedure under which the selection is likely to be taken. This is necessary to prevent arbitrariness and to avoid change of criteria of selection after the selection process is commenced, thereby unjustly benefiting someone at the cost of others. In the instant case, there's no advertisement lodged. The state has filed the affidavit. It is silent on whether advertisement was issued or no, Lordship. Paragraph 8, Lordship, page number 58, paragraph 8. Just a short sentence, Lordship.
Yes.
As Article 14 is an integral part of a system, each and every state action is to be tested on the touchstone of equality. Any appointment made in violation of the mandate of Article 14 and 16 of the Constitution is not only irregular, but also illegal and cannot be sustained in view of the judgments rendered by this court in the case of so and so, so and so. All these are the cases relied upon, Lordship. (2020) Volume 2, GLT 903.
Yeah.
Lordship, paragraph 7 states about the facts 11, 14, 15, Lordship, and 16. 11, 14, 15, and 16, Lordship. This is a case pertaining to the state of Nagaland, Lordship. And the petitioner in this case, he has also challenged the appointment of the private respondent, Lordship. It was on the basis of land ownership, Lordship. Of the private respondent on the ground that no selection process was done, and also the petitioner being a genuine bona fide landowner was given a direction to.
But you are not pressing this point.
No, Lordship, I'm not pressing that. Lordship, I'm not pressing that. But as so far as the appointment of the private respondent is concerned, it is illegal, Lordship. That is my contention. The relevant paragraph.
Your main ground is that there was no advertisement.
No advertisement.
You are only pressing that.
Yes, Lordship.
But you have not taken this plea in your written statement,
Yes,
in
Lordship.
your writ petition.
Yes, Lordship. Yes, Lordship.
Now, whether can you raise this when you have not taken the plea in your written statement,
Lordship.
in your writ petition?
The mandate of Article 14 and 16, Lordship. It's a question of law. It can be raised at any stage, Lordship. Whether the requirement, the mandate of Article 14 and 16. Even this honorable court can, under Article 226, take cognizance, Lordship. What is such selection process was conducted or no, Lordship? It is illegal in the eye of law, Lordship. Article 14, 16.
No, but unless you take this plea in your writ petition,
Lordship,
how
no doubt, I have critically stated that the appointment was illegal, Lordship.
No.
On the ground,
my query is different.
Lordship.
You
as
are
far as specifically advertisement, no, Lordship.
So how they would respond to it in their affidavit?
Lordship, I stated that against constitutional scheme for public employment, Lordship.
Because
And advertisement is
I'm
within the ambit of constitutional
I'm
scheme,
just
Lordship.
putting queries that had you been taken the ground,
Yes, Lordship. Very much, Lordship.
they would have come up
The
with some
appointment,
answers.
the appointment is against the constitutional scheme for public employment, Lordship. I have particularly stated, Lordship.
Okay.
And advertisement,
Where?
my respectful submission, advertisement very much under the ambit of Article 14 and 16. Lordship, paragraph 8. In my read petition, paragraph 8, the last sentence, Lordship, paragraph 8, page 6. Paragraph 8, page 6, Lordship. May I read the Lordship?
Yes.
The impugned appointment order was issued without conducting any selection process and hence in violation of the constitutional scheme for public employment and on extraneous consideration. Constitutional scheme, Article 14 and 16. And the requirement, the basic requirement of Article 14 and 16, equal opportunity, Lordship. How, Lordship? It is not the ruling that I have just relied upon, Lordship. Not by just inviting from the employment exchange, Lordship. That does not fulfill the requirement, Lordship. It has to be from the open market advertisement, Lordship. All these are the requirements under the constitutional scheme.
Now, why you applied for the post after coming to know that there is a vacant post? Or,
yes, Lordship.
Or some kind of, you are put to some notice that there is a vacant post available.
There was no notice at all, Lordship. Maybe the petitioner was also amongst the vigilant.
So all 81 applicants filed application,
Lordship,
after coming to know that there is a vacant post.
Vacancy, yes, Lordship, I have to agree that.
Okay.
But the rest, considering the plight of the thousands of unemployed youths, Lordship.
Yes, that is true.
Maybe I was also one amongst the vigilant applicants, Lordship. Otherwise, there are thousands and thousands of unemployed youths, Lordship. And if this is allowed to continue, Lordship, this will, and Lordship, if your Lordship may also continue.
But this is not a PIL.
Yes, of course, Lordship.
You can vouch for yourself only. But you knew about the vacancy. The aggrieved are those persons who never knew about the vacancy and process.
Lordship, for instance, Lordship, assuming but not admitting to the fact that I came to know about the vacant post. Yes. Lordship, however, Lordship, an illegal appointment, if this can be allowed to continue, Lordship, an illegal appointment which was made in violation of the constitutional scheme.
Okay.
Even if assuming but not admitting the fact that I knew about the vacant post, I was aware of the selection process, selection committee. That does not necessarily mean that the illegality has to become a legal action, Lordship.
Okay. Anything?
Lordship, that's my humble prayer before this Lordship.
Yes. Mr. Angami.
Yes, Your Lordship, as far as the advertisement is concerned, Your Lordship, I just wanted to start my submission by saying this. The petitioner can raise the issue of advertisement only when he has been denied to participate in the selection process. Then he can say that he is aggrieved by that selection process. Because he was not given an opportunity to appear on the selection process for which the appointment was made. He was very much a part of the selection process, Your Lordship.
But he was not aware what selection process you are taking.
Your Lordship,
He has applied for the post.
He participated.
No, he was not aware about the terms and condition, how you will be selecting, because there was no advertisement.
Your Lordship, there are only very limited terms and conditions as far as the grade 4 posts are concerned. And even in the selection process that they undertook, Your Lordship, in the meeting minute is categorically mentioned, very limited, Your Lordship.
Mr. Angami, my
Yes.
query is, one post is available for in public employment.
Yes.
Some people came to know about that vacancy.
Yes.
They applied.
Yes.
Many did not know about that vacancy, so they were deprived of from applying
Yes.
to the post.
Yes.
Now, those who applied does not know, and those who applied do not know that what would be the process which you would be following for filling
Yes.
up that post, because
Yes.
there was no advertisement.
Okay, Your Lordship. Then in that case, Your Lordship, in that case, if by this selection process, if the petitioner has been approved to be appointed, then in that case, will the petitioner still say that his appointment is illegal?
No, that is not the case.
Your Lordship, that is exactly the case, Your Lordship, because he has participated. And upon being found unsuccessful, now he is saying that the selection process has not been conducted. But the selection process has actually been conducted, Your Lordship.
What process was adopted?
Your Lordship, I'll show you. I'll show you. I have annexed everything, Your Lordship. I may be allowed to continue with my submission, Your Lordship. Now, Your Lordship, see. The petitioner are here before this honorable court only on 2 counts. Only on 2
They are
counts.
pressing for only one.
Yes, now they are pressing only for 1, which is illegal appointment of the private respondent made by the state government on the basis of no selection being done. That is the contention now, Your Lordship. Allow me, Your Lordship, to take my law to page 13 of my affidavit in opposition.
Of respondent number 3.
Respondent number 1 and 2.
Yes, page 13.
Page 13.
Administrative approval.
Correct. Seeking for administrative approval, Your Lordship. Your Lordship, for better understanding of the case, if I may be allowed to submit on the formation and the functions of the NCC, because these are under NCC, Your Lordship. The post in question is under NCC.
NCC.
Yes, Your Lordship. It's National Cadet Corps.
Okay.
It's under NCC, Your Lordship. Now, Your Lordship, this NCC falls under the Department of Youth and Sport Resources, Government of Nagaland.
Okay.
Lordship. And this Youth Resources and Sports has 6 wings, Your Lordship.
Okay.
Under it. If I may be allowed to mention those for better understanding of the case, Your Lordship.
Yes.
Your Lordship, the 6 wings comprises of 1, the youth wing. I have mentioned that in my affidavit in opposition, Your Lordship.
Okay.
At page number 4. It comprises of 6 wings: 1, youth wing, sports wing, Nagaland State Bharat Scout and Guides. In short, it is known as NSBSG, National Service Scheme, NSS, National Cadets Corps, NCC, and Task Force for Music and Arts, TAFMA. So these are the 6 wings under the Department of Youth and Sport Resources, Your Lordship. Now under this, Your Lordship, NCC. NCC is actually comprises of another 3 battalions. Which is, yes, Your Lordship. The first is known as 24NL1 Koi Kohima. 24NL1 Koi Kohima. 2 is 25NL Battalion Mokokchund. The third one is Air Squadron NCC Dimapur. And the fourth one is 1st Nagaland Girls Battalion NCC Kohima.
Okay.
Yes. And these are headed by a group headquarters NCC, which is at Kohima. So the NCC is scattered only in 3 districts, as can be seen, Your Lordship. One at Kohima, one at Dimapur, and at Mogokchung.
Okay.
Now, this NCC, Your Lordship, NCC, as per the requirement, the employees are deputed or assigned to various schools and colleges of the state of Nagaland. And therefore, Your Lordship, the post inclusion is attached at Worka Government College, Your Lordship. But however, the appointment is made under the headquarter Kohima, and he was only kept attached at Government College Worka, which can be seen from the appointment orders, Your Lordship. I've annexed the appointment orders, Your Lordship, of the post inclusion, which Your Lordship will find it at page 31. At page 31. The type copy, Your Lordship will find it at page 32 of my affidavit in opposition, my lord.
So this is a different order.
Yes. Your Lordship, if I may be allowed to read the first, only the first para. That is only the relevant para, Your Lordship.
Yes.
Sri Mambemo Lota is hereby temporarily appointed as NCC Lashkar. Your Lordship, the next is important. Under the establishment of the commanding officer 24 Nagaland Indent Koi NCC Kohima, in the scale of such and such, plus all other allowances prescribed by the government, amended from time to time with effect from the date of his joining, Vice Sri. Your Lordship, this is important again. Long Peng Shang Lota NCC Lashkar, attached to the government high school, Worka, retired. So the post in question was at Kohima. He was kept attached to the Worka government high school Worka, Your Lordship. Now, after this, Your Lordship, since the vacancy has arose due to the retirement of this person, Your Lordship, what steps have been taken by the government to fill up this post, Your Lordship? I want to take my Lordship there. And it starts from page 13. The process that has been undertaken by the state government to fill up this post.
Yes.
Page 13. This is a letter dated 25th of July 2022, written by the Directorate of Youth and Youth Resources and Sports to the government, with the subject, Your Lordship, if I may be allowed to read the subject.
Yes.
Administrative approval for conducting interviews for vacancies under the department. And the first para also, Your Lordship, may kindly allow me. Sir, on the subject cited above, with reference to your letter number, such and such dated 1/7/2022, I have the honor to submit herewith the vacancy list of 21 groups of Group D under the department as follows, for which approval for conducting interview is sought for. Further direction may kindly be given whether the posts are to be advertised or not.
Okay.
Your Lordship. I would like to take my Lordship to page 15, Your Lordship. Page 15, Your Lordship.
Just. Yes.
Page 15, my lord. This is another letter dated 21st of November 2022. This is also written by the Directorate of Youth Resources and Sports to the government. Your Lordship, subject, administrative approval for conducting interview for vacancies under the department regarding, Your Lordship, the vacant post. Now, this is the post in question, Your Lordship.
Yes.
Now, since vacancy has fallen because of the retirement of this Memo Lota, it has been sent to the government for administrative approval for conducting the interview. Now, Your Lordship, on the next page, page 16,
Whom you will interview?
interview the candidates who have applied for the post, Your Lordship.
How they will apply?
We have received numerous applications, Your Lordship, for various posts.
But there is no advertisement.
Why there is no advertisement, Your Lordship? I would satisfy my Lord, Your Lordship. I will satisfy my Lord. Allow me to take my Lordship to the documents.
Yes.
Page 16, my Lord.
The approval was granted.
Yes, the approval was granted. And Your Lordship, if I may be allowed to read the last para,
Yes.
it says, Your Lordship, starting from the first para, Your Lordship, for more clarity, Your Lordship. With reference to a letter dated 25th of July, 2022, on the above cited subject, I am directed to state that for recruitment to Group D, MTS post, Departmental Recruitment Board will not be required as per the OM dated 26/10 of 2017. You are therefore requested to set up a Departmental Selection Committee for selections of candidates for recruitment to Group D posts under the Directorate of Youth and Resources and Sports.
Yes.
Now the government is giving approval for setting up of a Departmental Selection Committee. In compliance, Your Lordship, to the administrative approval given, Your Lordship, the Directorate has by circular dated 9th of January 2023 constituted this Departmental Selection Committee where the Director was made as the chairman. Your Lordship will find that circular on the next page.
Yes.
Now in this circular, it was informed that this Department Selection Committee will sit on 11/1/2023.
Yes.
And as per this circular, Your Lordship, the Departmental Selection Committee sat on 11/1/2023, which Your Lordship will find it at page 20.
Yes.
Now, Your Lordship, I may be allowed to read this.
Yes.
Meeting minutes of the Departmental Selection Committee held on 11/1/2023 in the Office Chamber of Director, Youth Resources and Sports, Nagaland, Kohima, for selections of multitasking staff Group 4 posts, non-gazetted. The Selection Committee held a meeting on 11/1/2023 for selections of multitasking staff Grade 4 to fill up the 18 vacancies of MTS in the Department of Youth Resources and Sports. A total of 81 applicants was received by the Directorate, Youth Resources and Sports. The Selection Committee discussed and decided to base the selection by Home Department, OM dated 12/12/1968, in absence of any specific guidelines or service rules regarding selections of multitasking staff. Therefore, the Selection Committee scrutinized all the applications received and shortlisted suitable candidate as per the Home Department OM dated 12/12/1968 and as per OM dated 25/2/2021. The Selection Committee decided to recommend the shortlisted candidate as per Annexure B for appointment. So the selection was based on the office memorandum issued by the government of Nagaland, not on their own.
What is there in this office memorandum?
Yes, my lord. Allow me to take to this first office memorandum, 12/12/1968. Your lordship will find that at page 18.
But the question remains that it received 81 applications, but applications were never invited.
Yes.
Interview board was formed.
Yes.
As this was a post available in public employment.
Yes.
Was the state wrong in not advertising the said?
Your lordship, in fact, by an office memorandum, the department are exempted from making any advertisement on the approval of the government. I'll come to that notification, Your Lordship.
That has not been put to challenge.
That has not been put to challenge, Your Lordship.
Okay.
I'll try to satisfy my Lord on that count. So Office Memorandum 12/12/1968. Your Lordship, here we are concerned with para 5.
Yes.
This is class 4 appointment, peons,
Oh,
etc.
Where is that office memorandum?
Page 18, my lord. Annexure F of my affidavit of opposition.
Yes, yes.
Your Lordship, Office Memorandum dated 12 December 1968.
Yes.
The undersigned is directed to say that the government, after due consideration, has decided to prescribe the academic qualifications for direct recruitment to the various of class follows.
Yes.
1, upper division assistant, 2, lower division
So it
assistant.
prescribes the qualifications.
Yes, Your Lordship, we are concerned with 5. Group 4, appointment peons. We are concerned with this. Class 4, sorry, class 4, Your Lordship. And it says, Your Lordship, if I may be allowed to read this.
Yes.
A candidate should have knowledge of English, Hindi, or Nagamese. The academic qualifications as prescribed above are, however, subject to any relaxation as granted by the government for any underrepresented tribes in services under the government. The academic qualifications accordingly may please be incorporated in the respective subordinate service rules, be framed or already framed. The receipt of this memo may please be acknowledged. So for the group 4, a candidate should have a basic knowledge of English, Hindi, and Nagamese.
Okay.
There was also another office memorandum that was referred to by the selection committee. Your Lordship will find that on the next page. This is the office memorandum 25/2/2021. And this is the redesignations and indicative list of duties of multitasking staff, and the duties are prescribed therein, Your Lordship. Now, Your Lordship, as stated in the selection committee meeting minutes, there were 81 applicants, Your Lordship, for the post that was to be a fill up, Your Lordship. Now, Your Lordship will find the name of the petitioner on page 23, serial number 57.
Yes.
And the name of the private respondent, Your Lordship will find it as serial number 70. On the same page, my lord.
Yes.
Now, on the applications submitted by the private respondent, and certificate also was enclosed, wherein he possessed a degree in Hindi. Your Lordship will find that at page number 27. I am not well versed with Hindi, so Your Lordship, there's a translated copy made at page 28.
Okay.
Now, Your Lordship, the selection committee says that it clearly in the meeting minute, it says that this selection was done as per the Office Memorandum 12/12/1968. And Office Memorandum 12/12/1968 prescribes that for a class 4 post, a candidate should have knowledge of Hindi, English, and Nagamese.
Or Nagamese.
Or Nagamese. So therefore, Your Lordship, whatever has been prescribed in the Office Memorandums 12/12/1968, Your Lordship, the petitioner, the private respondent have it.
And the petitioner?
No.
He does not know.
He does not have this.
He does not know Nagamese.
His knowledge of English comma, Hindi or Nagamese. English, Hindi or Nagamese.
It means what?
I'll explain that.
Okay. Now,
Lordship.
what is your submission that
Lordship,
eligibility criteria is
Yes.
what he should know English and
Hindi,
as well as Hindi.
Hindi or Nagamese.
So he should know English and Hindi
Or
or
Nagamese.
English or Nagamese.
Yes, Your Lordship.
That is
And-
your submission.
Yes, and since the private respondent have it, this becomes a merit for the private respondent to be appointed, Your Lordship.
And the petitioner,
Does not have a Hindi qualification,
but
Your Lordship.
he has whether he knows Nagamese or not. Because Nagamese is Hindi or Nagamese.
Why Hindi was given to me is that NCC is headed by a commanding officer who is a
No,
direct of a colonel in the army.
I'm not on that. I'm on submissions made by
Yes,
government council that was the eligibility criteria. To exclude somebody,
yes.
you have
Not
to.
excluding, but I'm talking about the merit. Merit, preference that was given.
But that is not there in the office memorandum that Hindi would be given preference.
Your Lordship,
It was only an eligibility criteria.
Your Lordship, the office memorandum says a candidate should have knowledge of English, Hindi, or Nagamese,
Yes, that means English or Nagamese or English
or
or
Hindi.
Hindi.
So, Your Lordship, if a person have that knowledge, yeah, in addition to Nagamese and English, Your
But
Lordship.
that is not the criteria that in addition to Hindi, Nagamese you should know.
No, Your Lordship. Your Lordship, the office memorandum
And
clearly says that.
it does not say that preference would be given to person knowing Hindi. So
Should
therefore,
have, Your Lordship.
therefore advertisement is necessary, which lays down the criteria for selection. On what basis you selected?
Your Lordship. Then in that case, I have mentioned this in my affidavit in opposition, Your Lordship. The petitioner is also not saying that this should be the only criteria. Because the office memorandum
No,
was
petitioner
followed.
is not saying, but you are saying that.
Yes, because the office memorandum was followed while making the selection. And the office memorandum says a candidate should have knowledge, some knowledge, see, Your Lordship, some knowledge of English, Hindi, or Nagamese. Some knowledge. It's written. A candidate should have some knowledge.
Suppose if a candidate does not know Hindi, whether he would be excluded from consideration. If yes, then matter would be different. If no, then you must have some reasons to exclude other 80 petitioners.
Your Lordship, your Lordship, if a criteria is set in an office memorandum for selecting certain individuals or candidates,
Yes.
and that criteria says that a person should have knowledge about something, and the person who have that knowledge will it not be preferable before the department? Because the office memorandum that was followed for selecting the candidate itself says that a candidate should have. It's not may have. May means it can be considered, it may not be considered, but it says should have
Some knowledge about Nagamese or Hindi.
English as well.
English as well. But there is an option between Nagamese and Hindi. So you may know Nagamese or you know Hindi.
Yes. However, as my learned friend was submitting, NCC is actually controlled by the outside.
But that is not in the office memorandum that Hindi would be given preference.
Oh, Your Lordship. In that case, allow me to proceed then, Your Lordship.
Yes.
Then, Your Lordship, administrative approval was thereafter given for appointment.
On what basis the petitioner was, the private respondent was selected?
on the recommendations of the screening committee. Not only the private respondent, but 18 of them.
Whether all 81 were called for interview?
Yes. Yes.
You also appeared before interview. You also appeared before interview board.
Yes, Lordship.
Okay.
So it is an admitted fact that they were called for interview. Now, Your Lordship, as far as the advertisement is concerned, allow me, Your Lordship, to take, there are 5 office memorandum here, Your Lordship, which has been annexed by the petitioner, though they are not pressing it. Allow me to go through and I'll try to satisfy my Lord as to why advertisement could have been exempted and could be exempted, Your Lordship.
Yes, that is the main point.
Yes. Page 19 of the writ petition, Your Lordship. Annexure C.
Yes, Annexure C.
Annexure C. Your Lordship, the relevant para is at page 20, para 4. Para 4. And it starts with all direct.
Yes. Yes.
All direct, married, my lord. All direct recruitment vacancies in Group 4 posts in district offices of the department shall be filled up by the indigenous inhabitant of their respective districts. In making recruitment to other grade 4 posts in the directorate and secretariat level offices, the reservation policy for backward tribes shall be adhered to. All Group 4 appointments shall be with the approval of the government. So, Group 4 post has to be appointed from among the indigenous inhabitant of that particular district.
Yes.
Your Lordship. The next is the office memorandum dated 24th of March 2018, Your Lordship, on the next page.
Yes.
On the next page, if I may be allowed to read this, Your Lordship.
Yes.
Procedure for filling up of non-gazetted posts in department. In pursuance of the decision taken by the Cabinet in a meeting held on 28th of November 2017, and in continuation to this Department Office Memorandum of Even Number, dated 26 October 2017, it is hereby clarified that all direct recruitment vacancies to be filled up through the Departmental Recruitment Board shall be invariably be advertised. Your Lordship.
So it speaks about advertisement.
Yes, Your Lordship. Yes, yes, Your Lordship. When it speaks about advertisement, Your Lordship. Allow me, Your Lordship. Recruitment of, on the next page, Your Lordship, notifications dated 17th of July 2018.
Yes.
It says, in pursuance of this department, recruitment of Group 4 posts in the district offices. District offices, Your Lordship. In pursuance of this Department Office Memorandum dated 26 October 2017. This is the first office memorandum that I have read, Your Lordship. It is hereby reiterated that appointment of Group 4 posts in the district shall be filled up by the respective indigenous inhabitant of the district only. It is reiterated. 2, in this connection, all departments are directed to submit a conciliated report on all the appointments made to Group 4 posts in the district with effect from 26/10/2017 till date to this department, letters by 14th of August without fail. So again, it is reiterating the 2017 Office Memorandum, Your Lordship, where Group 4 posts are to be filled up only by the indigenous inhabitant of that particular district. The next Office Memorandum, Your Lordship, 3rd of March 2022. On the next page, my Lord. Now it says, subject, filling up of Group D posts in the department corrigendum issued regarding. I may be allowed to read.
Yes.
The procedure of filling up of Group 4 post in the government has been laid down by Office Memorandum dated 26/10/2017 and 24/3/2018, Your Lordship. 24/3/2018.
Yes.
The latter memorandum lays down that applications for recruitment to the post shall be called upon through open advertisement. 2. Following difficulties expressed by various departments on account of the facts that in many cases, Group D posts such as Chokidar, Malis, and peons are filled up by landowners or on compassionate grounds, and locally at the district, subdivisions, or village level, the matter was considered by the cabinet in its meeting held on 9th of February 2022 and 22nd of February 2022. In order to remove such difficulties, it is hereby directed that the conditions of advertisement is dispensed with, which whenever such difficulties are faced by department, as long as a fair and transparent eligibility criteria and process is followed in all such approval of the government is obtained. So it has been dispensed with.
This has not been challenged.
Yes. This is not under challenge, my lord. So on two counts, your lordship, the issue of advertisement, number one,
Yes.
has been dispensed with, but with the condition that approval of the government has to be taken. Now, your lordship, whether approval of the government as far as the private respondent appointment is concerned, whether it has been taken or not, it can be seen from the document that I have just read it out, your lordship. Approval was given by the government on the recommendation of the Departmental Selection Committee, which was directed to be constituted by the government itself. Your lordship. Number two, your lordship. The petitioner was very much a part of that selection process. It is not the case of the petitioner, your lordship, that he has been deprived from getting appointment to the post in question by denying him to appear before the selection committee. It is not the case of the petitioner. He appeared. And the selection was done by the selection committee, recommending the name of the private respondent. Then in such circumstances, your lordship, where is the local standard of the petitioner after appearing the selection process to even challenge or to come before this honorable court and say that the advertisement has not been made when he himself was a candidate before the selection committee? And therefore, your lordship, it has got the repetition deserves to be dismissed, my lord.
Yes, Mr. Muzai. We are for the
Lordship, on the issue of the notification, Lordship, I will not be repeating the submissions. However, Lordship, going by the repetition, Lordship, I can see the prayer. Page 12, Lordship. Prayer, Lordship. Because ultimately, this is the ultimate target of the petitioner. What he's seeking, Lordship. Firstly, A, question set aside the impugned appointment order dated 16/1/2023 in respect of respondent number 3 issued by the Director of Youth Resource and Sports Kohima, respondent number 2 being illegal. B, direct the state respondent to consider the case of the petitioner for appointment to post of NCC Laskar at GHS's MTS grade 4 at GSS Oka against vacancy caused by retirement of Marhum Mulata for being an indigenous independent of Oka district. Now, Lordship, as my learned friend has already submitted, this post is not under the Oka district. Firstly, this is the case of the petitioner, indigenous inhabitant. My learned friend has already pointed out, Lordship, the post falls under 24 NCC Kohima.
Yes.
The petitioner is banking his case in the indigenous inhabitant.
Yes.
Secondly, Lordship is relying on land ownership. If he is seeking appointment on land ownership, Lordship, he should have applied under the school education department.
No, now he's not pressing for.
But the prayer, whether he can go beyond his pleading. Lordship, argument has to be on the pleading, not beyond the pleading. Now he has taken a ground which is not even his prayer.
And he has not put to challenge that notification which dispense with the advertisement.
Yes.
Even if we assume
Yes, Lordship.
that advertisement is necessary for every public post.
Yes, he should challenge that notification.
That notification has to be challenged.
Yes, Lordship. That has not been done.
That has not been put.
Yes, Lordship. Now he's assailing to a ground where he doesn't have a ground. He has not put the challenge of that notification. Lordship, basically what I'm trying to say.
Yes.
Now, my selection to the post of Laskar, I was interviewed, Lordship. I have no qualification.
What is the name of the private respondent?
His name is Nipehe Lohe.
Lohe.
Nipehe Lohe. Why I was given preference, Lordship? I appeared in interview, I know. NCC is manned by a commanding officer who comes from the army on the petition. Most of the staffs are from the army because they have to train the cadets. They go through military training. So those people coming, they are not well acquainted with Nagamis. Hindi, Durkabat. We have to know Hindi. As essential qualification. That was taken in consideration because Youth Resource Department mans the NCC office.
But office memorandum does not.
No, Lordship. I'm not saying that. I'm not basing on office memorandum. My advantage of having Hindi was that I was preferred over other candidates.
Then otherwise it should have been mentioned in the advertisement.
But the advertisement has been dispensed with.
Yes, and that he has not challenged.
That he has not challenged.
Otherwise, how the candidates would be knowing who would be given preference?
Yes, Lordship. So, but like Lordship has rightly pointed out, and my learned friend has already brought to the notice of the court, that office memorandum is not under challenge, Lordship. Now, it was a selection process. My learned friend is not denying the fact. He participated.
In the interview.
Yes, he appeared. He might know Nagamis, a little bit of English. My advantage was I had additional, besides the Nagamis and English, I have Hindi knowledge. And a Laskar post, Lordship, more or less to do with MTS, dealing with the staffs, dealing with the army personnel, who are more well acquainted with Hindi. That was my advantage, Lordship. But when I appeared in interview, I had the advantage. I had the qualification. With that level of confidence, I have gone for an interview, Lordship. Now, I have already stated in my affidavit, the petitioner is confused as to whether he is seeking appointment on indigenous inhabitant or on landowner. Because as per the writ petition, these are the main contentions. The advertisement is afterthought, after we file the affidavits. Lordship, the interview, I was selected on 16/1/2023, Lordship. Lordship, the dates are very important. 16/1/2023. Interview held on 11. My appointment order issued on 16/1/2023. The writ petition was filed somewhere in the month of December 2023. 15 December. If he was at all aggrieved, Lordship, he could have applied for RTI. Nothing stops him. If he's doubtful about how the procedure was conducted, he could have applied RTI. He was sleeping over the matter. Then suddenly he wake up after a gap of more than 11 months. I have to challenge the appointment of the private respondent. 11 months, Lordship. After 11 months, he is challenging my appointment. And that too, knowing fully that he also participate, I also participate in that process. So whether the process can be termed as illegal, Lordship, as mentioned in paragraph 8. Tomorrow I appeared in judicial service, I fail, and I come before this court and I say that no, the process is illegal because I failed. Lordship, is this a ground of the petitioner? I participated, I failed, and I say it's illegal now. If he pass, then it's legal.
He's not saying so.
No, basically that is what his petition is about.
Okay.
Now he's assailing to a ground. I'm repeating, Lordship, about the advertisement, which is not even a ground in the petition.
Which is not pleaded in the
and it's not pleaded, not even challenged also. So under such circumstances, whether the petitioner has made out a case seeking for intervention of this honorable court in interfering with my appointment. Lordship, my affidavits, in my affidavit, I have placed my document. These are the documents that I have placed before while applying for the post. Lordship, annexure. Annexure 3 series, page 14, Lordship. This is my first certificate. That is National Language Introduction Test. This is my class 10. Then the second is diploma, National Language COVID. And lastly, my National Language Ratna. I doubt whether the petitioner has got these certificates. And Lordship, lastly, the criteria for MPS, Lordship.
Which is your Hindi certificate?
Lordship?
Certificate that you have done course in Hindi?
Lordship, the one that I've just shown. Annexure 3, page 14 of my affidavit.
It speaks about Assamese language, not Hindi. It is a certificate which says that you have knowledge, general level knowledge about Assamese language. Though certificate is in Hindi, but it does not speak about your proficiency about Hindi language. You read the translation.
Page 17, Lordship. COVID. This is a degree.
Or additionally, it may be in you have the additional knowledge about Assamese language.
In addition to the Hindi, yes. Then the Ratna, diploma in Ratna, Lordship. No, Lordship, on the affidavit of the state respondent, Lordship, at page 19, though my learned friend has read it out, what are the duties of an MPS, Lordship? So interview will be not asking do you know how to wipe a table or carry a file or deliver a duck. Why I'm saying this is, Lordship, I had an additional qualification of Hindi. Now, these are the requirement of MTS duties. A, physical maintenance of records of the section, general cleanliness and upkeep the section unit, carrying of files and other paper within the building, photocopying, sending of fax, etc. Other non-clerical work in the section unit, assisting in routine office work like diary, dispatch, etc., including on computer, delivering of dark outside the building, watch and ward duties, opening and closing of rooms, cleaning of rooms, dusting of furniture, cleaning of building furniture fixtures, upkeep of park, lawn, potted plant, etc. Any other work assigned by the superior authority. So basically, the interview will be on your qualification. That is how I've applied for the post, Lordship. Besides the additional point that I've raised, Lordship. So, Lordship, as far as to sum up my submission, the petitioner has filed a petition seeking the intervention of the court in my appointment, firstly on indigenous inhabitants, secondly on land ownership basis, which now they are saying he's not going to press. That means his petition is gone. If he's not pressing on these two, his petition is gone. He has no locus standi. I make a prayer before the court, and then I say, no, I'm not going to argue on this point. The matter is there, Lordship. Now he's acceding to another ground, which is not even a part of the petition. That is advertisement. Even assuming advertisement is required, Lordship. Even assuming that advertisement is required, whether he has taken a ground in the petition.
Yes, to challenge that notification which dispense with the advertisement.
Yes, exactly. That's on the question of law.
Okay.
That's one solution.
Private secretary.
Lordship, if I may, just 2 minutes, Lordship.
Yes.
In order just to clarify, Lordship, 1 or 2 grounds, Lordship. Firstly, Lordship, 81 applicants, Lordship, or applications were scrutinized along with the documents, Lordship. Only the 18 who were selected, they faced the interview. Only the 18. And my documents, Lordship, the petitioner's documents, along with the other 81, our documents were scrutinized. We were not summoned to appear before the interview board. Only those 18 who were selected. That is my first clarification, Lordship. Therefore, only my documents were scrutinized by the board or by the committee, Lordship. I did not face the interview, Lordship. That is one, Lordship. Just to clarify, Lordship. Second, Lordship. Second, Lordship. With regard to why I did not challenge the office memorandum, that has dispensed the advertisement, Lordship. That has dispensed the advertisement. Lordship, if your Lordship may kindly allow me to read it, Lordship. Page 23 in my read petition, Lordship. I'm referring to the same office memorandum. Just one word, one term, Lordship.
Page 23.
Page 23 of the read petition, Lordship. Annexure F, page 23. Of the read petition. The department, they have relied upon this office memorandum, saying that advertisement has already been dispensed. Basing on this, relying upon this office memorandum, they did not issue the advertisement. That is the standard. Page number 23.
Yes.
If the Lordship got it. May I read only the paragraph number 2, Lordship? Paragraph number 2.
Yes.
Following difficulties expressed by various departments on account of the fact that in many cases, group depots such as Jokidar so-and-so are filled by landowners or on compassionate ground and locally at the district's subdivision or village level. The matter was considered by the cabinet in its meeting held on so-and-so and so-and-so. In order to remove such difficulties, this is important, Lordship. In order to
Wherever
remove such difficulties,
you are pressing for the word wherever.
Yes, Lordship, wherever. They have to express such difficulty. Nowhere in the circular, nowhere it has stated that this were the difficulties why they dispense with the advertisement, Lordship. It does not generally apply to all the departments, Lordship.
So they have to seek leave for not advertisement.
Exactly.
For not
Lordship, exactly,
advertising.
Lordship.
From the government, they have to seek leave that these are the
Difficulties they have faced.
Therefore, this advertisement should be dispensed with.
Exactly, Lordship. Even otherwise, Lordship. Now, this office memorandum has dispensed the advertisement, which is against the constitutional mandate, Lordship. And this is an executive instruction under Article 162, Lordship.
No, but you have to challenge this.
Lordship, they have not mentioned the difficulty, Lordship. They have not mentioned the difficulty. So they did not comply with this office memorandum. They did not comply with the office memorandum. If they have complied, if they have expressed the difficulty, I'll be compelled to challenge, Lordship. It does not generally automatically apply to all the departments. The department concerned has to express the difficulty. Even otherwise, Lordship, my respectful submission, Article 14 and 16 cannot be override by a mere executive instruction under Article 162, Lordship. This advertisement cannot be done away in violation of the constitutional mandate under 14 and 16. In no way, Lordship. Let them come in, Lordship, satisfy your Lordship that Article 162 can override Article 14 and 16. It is an executive instruction at the most under Article 162. Cannot override the constitutional mandate. That is my respectful submission, Lordship.
Heard Mr. Muazzamir. I'm reserving it.
It's not under challenge. So whether he can take this draw, Lordship.
Heard Mr. Muazzamir, learned counsel for the petitioner. Also heard Mr. N. Angami, learned senior government advocate for state respondent, as well as Mr. N. Muzoi, learned counsel for the respondent, private respondent number 3. Hearing concluded, judgment reserved.
Lordship. Obliged. Much obliged.
Pleasure.
For hearing, item number 31 to 33.
This you, after making it okay, you send it to my chamber. 2 judgments, citation, 3 citations, judgments should be required. Yes. Mr. Tiba form is not there.
Monk is in his office. The job goes now is 3 read petitions, my lord. WPC 69. That is.
The issues are same in all 3 writ petitions.
My lord, all 3.
All 3 were electricians.
Yes, in the power department, while performing their assigned duty, all 3 of them.
This is WPC. WPC number
69, 2018. Then WPC 70, 2018. And WPC 71, 2018. Like that. The petition wise, first I've given bold one, that is WBC 69.
Yes.
The petitioner is the wife of one less Ong Tu Cholan, the deceased. In the petitioner belongs to a scheduled tribe. Not only that, a declared officially backward tribe of Nagaland. There are some forward tribe there are some backward tribe in Nagaland. So it is officially declared as a backward tribe.
Which tribe?
Chang. The present petitioner is Chang.
Chang.
Yes.
CHANG.
Yes. So, my lord, the petitioner's husband, late Ongtu Chulan Chang, Chulan, appointed unfixed bail under STO electrical number 2, executive engineer electrical on 29/11 of 85 with effect from 15/11 of 1985. That is Annexure 1, page 11 of 30 December. This is not eligible to type copy is 11A.
Yes.
So after this, and my lord, promoted. That is, nomenclature is work charge. But if our knows only promotion, fundamental rules is clear that as per fundamental rules, if somebody is promoted, his service have to be taken as regularized of his earlier appointment. If our if our 9/30, that is include Shaleon in the litigation. My lord, if part 13 is the, if part 9, bracket 13. If part 9. Bracket 13 is, it speaks about the lien.
Lien.
Yes. So lien means the title of a government servant. So Government of India's orders, their extract is their extract C, on promotion, if the recruitment rule do not prescribe any provision an officer promoted on regular basis after following the prescribed DPC, etc. procedure.
Where are you reading?
My lord, the Government of India's decision after 13. Government of India's orders, my lord.
Yes.
After bracketed 13.
Yes.
Then extra is the right after the government GIO is the extra. If I may be allowed to read out the whole extract, my lord. A is general. 1. Confirmation will be made only once in the service of an official which will be in the entry grade, my lord. So it has to be taken as confirmed. Confirmation is the link from the availability of permanent vacancy in the grade. Then I may be allowed to take your lordship to see on promotion. What will be the condition? If the recruitment rules do not prescribe any professional officer promoted on regular basis after following the prescribed DPC, etc. procedure will have all the benefit that the person confirmed in that grade would have. So earlier appointment in on promotion will be taken as confirmed or permanent. My lord, Parat page annexure 2, that is promotion. I may be allowed to read out.
Yes.
Page 12. Office memorandum. Subject promotion from work charge master to work charge locally. So it is a promotion. In supersession of office number such and such, master are hereby promoted to work charge locally in the scale of office such and such. DA additional admissible at the rate of such and such onwards, that is 1/1/1997 onwards, including medical such and such. The scale of the offer does not confer any right upon the government servant mentioned in Annexure 1 to claim regular appointment under the Department of Power. This, whatever they have written, it is a promotion. It cannot override the FR once it is a promotion. The service of employee under this order, is it time for recess? What?
Okay, we'll continue at.
My lord, since I will not be completing right now.
We'll continue at.
My lord.
And you're that Government of India's order which you were reading. It is not there in this book. Please, please.
Yes, I will furnish you. Let me see. Yeah. Open. No.
before the deputy commissioner, as per the discount for
I'll show your presence.
my presence for the AG in all the trees. I'm the new person.
Malok, annexure 2 of my petition, page 12. This is not a loan case. This promotion is as Malok. In subsection of such and such, skill pay allowances the additional day as admissible at the rate of such and such onwards, 1197 onwards, including medical allowance at the rate of rupees such and such, my lord, as recommended by the Departmental Selection Board. So it is Changtongya Division, Mokchong Division, Mokchong Transmission Electoral Division, Tunsang Division, the petitioner comes under that. Kohima Division, Oka, so as many as 91. This Departmental Selection Board recommendation is not denied, man.
So what is your contention?
My lord,
That
it is
the petitioner was promoted from work charge Mazdur to work charge Jugali.
my lord,
So
as recommended by the Departmental Selection Board. So that is a regular appointment. My lord, when it is a selection process, that is regular. And over and above what I'm trying to impress upon your lordship is that when it is a promotion. Your lordship, particular portion, I check with your lordship. I annex that in the additional affidavit in reply filed by me on 25/7 of 2023. Additional affidavit in reply.
which page?
Page 59. And 60.
Yes.
Then after this due process of selection in a promotion, well, performing duty, my lord.
No, in page 60, what you are referring to?
59 is the legal FR9.
Yes.
Bracket 13 is the idle over of a government servant who holds substantively. And Government of India's orders is next below 13. And if I may be allowed to read out the whole lot.
No, what
Now-
you are relying, what you are relying.
What I'm banking is extra, page 60.
Yes.
Extra.
Extract which?
A, B, C. And promotion, what will be the quote? If the recruitment rule do not prescribe any provision, an officer promoted on regular basis after holding the prescribed selection process in the present case will have all the benefits that a person governed in that grade would have. My submission before Lordship is that this promotion was not under anybody's whims. It was after a departmental selection board.
Okay.
Let's say that there was no selection board. If it is a promotion, if our 9 clause 13 comes into play, that it has to be taken as confirmed in permanent. That is what I'm trying to. So what happened while he was assigned for Assam Rifle Knuckle and Range, Winsa. He died on 16/2 of 2010. Assignment is with page 37. It was not often duty. It was assignment 19 January 2005.
Page number 37.
37, yes. Date may be wrong, my lord. In the interest of public works, the following staff are hereby engaged to work extension of 11 kV, 3-phase transmission line, and 250 kVA, 11 or 250 kV substation under BMTY at Assam Rifles, Nagaland. So the date of this assignment was 16/2 of 2010. Name is given. Serial 3 is Hong Tu Chang. Then what happened is that on that day, he was electrocuted, died on the same day. So he served the department from 1985 to 16/2 of 2010. That is 24 years, 2 months in 18 days. When it is extraordinary pension, family pension, the question of length of service is not the main issue. However, to make it that how many days that this is observed, that is what I am trying to say.
Okay.
Then the petitioner he filed WPC 87. He of 2016 on 31/5 of 2016. In the single judge, page 38, it starts from 38. Page 6, operative part, my lord.
This writ petition was filed
By the same petitioner.
seeking what relief?
My lord, family pension in
Okay.
extra share.
Then
para 6. The present case is also a fit case for correcting last sentence to regularize the service of the petitioner's husband posthumously for the purpose of pension and pensionary benefits. Then para 7, page 43. Coming to the prayer of ex gratia, there is no dispute that the petitioner's husband died while performing his duty. Normally, the family members of the government servant who died while performing their duties are given such ex gratia. There is no contention from the government respondent that the scheme for payment of ex gratia in case of death while performing duty as provided under the Government of India OEM dated 11/9/1998, issued by the Government of India, Department of Pension and Pensionary Welfare. It's not applicable instead. Paragraph 5, clause A of the said OEM. It is
No, in this order, direction was given to give pension.
Yes.
Then what happened?
Then it was not.
Then you filed contempt?
My lord, there was after this, there was a review.
Review by the same court?
Yes.
Okay.
Yes. About the amount. It was on the question of amount. In this one, 5 lakhs was the amount directed.
Some water has spilled. So soon.
Then,
okay, now what happened? The court directed to give you ex gratia
of 5 lakhs in the writ petition.
and also directed to regularize
Yes, for family pension.
family pension.
Yes. Yes.
Then what happened?
Then government filed review petition. Review petition number 9K of 2017. Page 47. In this case, respondent, the petitioner in the petition husband died of electrocution while performing his duty. Therefore, his case is squarely covered by Para 2 of OEM issued by the state government given above. As for the contents of the parasite and such, the state government has the discretion to determine the ex gratia amount to be granted to government servants who are killed while performing duty from 1 to 5 lakhs, depending upon the nature of duty of the deceased government. So, in view of the above, the judgment order that is modified to the extent that the petitioner will have the discretion to determine the amount of ex gratia to be paid to the respondent from 1 to 5 lakhs as per the nature of the duty of the deceased government servant. Then, when this honorable court gave a discretion, because review was only to the extent of 5 lakhs. Review was not in respect of the family pension.
Yes.
Then
that quantum was
either from 1 to 5.
Left to the discretion of
Yes,
the government.
yes. Then the government as well as the petitioner file appeal. That is page 48. The POA 19 is by the petitioner. Then 20 is by the government. Then this appeal court, it starting from page 48, operative part maybe page 9,
59.
51. Para 9, page 51. In respect to the judgment orders and such, other two petitioners, that is 144, that is subsequent to the present one. In 144, 16, the state government did not file any review. However, the state respondent filed appeal in respect of all the judgment in order in all three petitions, challenging the direction of the single judge for posthumous regularization for the purpose of payment of pension in ex gratia payment, on the ground that the petitioner's husband and father were not entitled to any ex gratia payment in terms of the order dated 11/9/1998 issued by the government of India in OM 6/6 of 1995 issued by the government of Nagaland. The case of the state government in the above appeal is that the petitioner's husband being work charged locally assistant lineman. The petitioner was not entitled to any family pension and no direction for posthumous regularization could be given. Then operative part, my lord, page 56, para 19. In view of the above reason, the impugned judgment such and such, order dated such and such, passing such and such, these are the three different petitioners are not sustainable in our set aside. However, in view of the submission made by the learned senior additional AAG, that the cases of the deceased work charged employee would be considered for posthumous regularization, we direct the state.
Where are you reading? Para?
Para 19.
Para 19.
56, page 56. In view of the submission made by the learned senior additional AAG that the cases of the deceased work charged employee would be considered for posthumous regularization, we direct the state respondent to consider the cases of the deceased work charged employees in all three writ petitions for regularization 1 day prior to their death, along with the other eligible candidate for the relevant period of time in terms of OEM dated 2004 as amended from time to time. That is regularization of work charge. This will of course be subject to the availability of regular vacancies during the lifetime of deceased work charge employee in event of regularization. All entitlement regarding pension and other pensionary benefit will be paid to the petitioners. That is the.
Then what happened?
Then what happened is that the impugned communication, page 57. What we are trying to see is that January 2018, 57, to such and such. In the light of judgment order passed in writ appeal 19, such and such has considered your case and is concluded as under. We intended 22/9/2004 is under. The regularization of work charge employee will be done against available vacancies. 50% of regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees. In the remaining 50% will be filled up as per normal rules of recruitment. Work charge employee will have the right to be considered first for regularization against 50% of all vacancies of similar nature in department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior-most work charge employee in the relevant category will be regularized subject to his fitness for the fact and post in oriented 17.315 as under. All existing work charge and casual employees of various departments who are enjoying skill of pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of these posts into regular ones. Personal to them is subject to fulfillment of conditions as indicated in notification. What we are saying is the department has examined your case and has arrived at the finding that your case is not covered under purview of BNR dated 22/9/2004 and 17/3/2015. Therefore, the department is required to inform that your prayer for regularization is hereby rejected.
What wrong they have committed?
My lord, what happened is this.
Where is the wrong?
We are saying that the petition, the deceased, you were not entitled for regularization. So what happened is that this honorable court tradition is why your affidavit projecting the position about your seniority. Additional affidavit in position. And what we have projected is that the disease stands at 809, 59, 99, 989. Yes. Serial 989, that is your additional affidavit. In 7/4 of 2026.
Page number?
Page number 21.
Yes.
Then it starts from page 5. Tentative seniority lays of work as to quality. Electrical as an 143,008.
This is what you want to show.
We are showing that this is serial 989 02 W02 page 21. The last name is page 25, my lord. Serial is 1204. In the Angsi.
Yes.
Date of training is 6907, my lord.
Yes.
This is pertinent for the reason that it also includes tentative scenario page 26, my lord.
Yes.
As on November 2021. In this, as on 2021, the last person that is in the RC is not in the seniority list of 2021. The reason is that all these people, they are regularized. That is why their name doesn't feature in 2021. Am I clear to your logic? That the reason this work charge as on 1/4/2008, which ends in serial 1204. In year 2021, that is Annexure C, page 26.
Yes.
None of the
These 1, 2, 3, 4.
yes, 1204. It is none of them are in this 2021 work charge. Then the seniority list. The meaning is that all of them are regularized.
Or they may not be in service.
My lord, it may be, but fact remains that none of these who were shown in 2008, they are in the 2021 list. Neither by all of those personals, they are regularized. To this statement, I filed an additional affidavit in reply, my lord, on 25/7/2023.
The earlier seniority list was of 2008.
2008. Your lordship may kindly look into my additional affidavit in reply. File on 25/7/2023.
File on 7.
25/7/2021. Additional affidavit. It's a bulky one, my lord.
Yes. Page number?
My lord, I may be allowed to start from the beginning.
Yes. What do you want to show?
My lord, all the juniors to the deceased, they have been regularized. That is what I'm trying to.
You have their regularization
My lord,
order.
that is why it becomes so bulky.
Okay.
My lord, I may be allowed to take your lordship to page 4.
Yes.
Up to 5 is about the selection in brothers. So it is not a question of work card. It is a regular that is up to 4. That such and such appointed on 29 November 85 as Chokali and fixed fee in promoted to Chokali in the best skill as recommended by the Departmental Selection Board. On 27/9/2000, many of the work charge Chokali who were appointed after his promotion. This is promotion. The one he has reflected here in serial 989. 989. Date of appointment given as 3/9/2000. That is the whole issue. Otherwise, you are not denying about your appointment order.
3/9.
This is 3/9/2000. That is the promotion date, not the appointment date.
But they are showing it as date of appointment.
My lord, that is what exactly I am saying.
But your appointment was in 1985.
My lord.
Okay.
So you are showing a wrong date, and that is a promotion through selection process. So it cannot be in the work charge list.
Otherwise, in work charge list, your position would have been much higher. Senior.
Much higher, my lord. That is what I am trying to say. They are showing a wrong date of appointment.
Had the date of in 1985.
Yes. Yes. Had
is
it
taken
been
into
85,
consideration.
it will be a different story.
Okay.
Over and above, my lord, what I am trying to see is that recolorization I am including in this one. Page 4. Recolorize, that is junior to late on to Chang. That is, if it was taken as 29 November 85, that is the actual date of appointment, then annexure 11.
Page.
'61.
What is this?
What I'm trying to show is it starts from serial 70, who are junior to the deceased. Serial 70, 71.
Krishna Prasad.
Yes. It starts from 70 up to 124. Were junior to the petitioner, the deceased. Then annexure 12. Order number 260, dated 4/19/2000.
Which page?
Page 68.
No, in page 62, the names mentioned in serial number 70
to 124.
124 are junior to you.
Yes, my lord.
Okay.
Then annexure 12. Order dated
Page number, please.
19/4/2020. Page 68.
68.
Yes, 9 to 16 are junior to the petitioner, the deceased.
What is this annexure 12?
Pardon, madam.
What is this annexure 12? What this order is? In this
This is all article regularization, madam.
regularization orders. Okay.
In junior to the deceased. That is what I'm trying to prove.
But this regularization order was passed when the deceased was no longer there.
No.
After his death.
Madam. Annexure, my lord, 11 is before the date of the deceased. That is 29/9/2009. The deceased died on 16/2/2010. Just taking annexure 11 itself, it is clear that the petitioner, when he was alive, his junior were regularized.
Annexure 11 is that page.
We want to
Okay,
67, my lord.
okay. So serial here this serial number
from 70
from 70 to 124.
Yes.
Were junior to you.
Yes.
And this regularization order was passed when you were alive.
My lord.
Okay. So what is your submission?
My lord, the deceased could have been regularized way back on this particular day. If the proper regularization was done as per the seniority, the whole question arises because his date of appointment is wrongly issued.
Okay.
That is the whole issue. It is not the creation of the disease. The employer knows when the person was appointed. But
So your case is other work charge employees who were junior to the deceased were regularized even when the deceased was alive as well as thereafter also.
Yes.
And deceased was not regularized because his date of appointment has been wrongly shown
as 2000
when he was promoted.
Yes.
As
yes. Yes.
Okay, that is your case.
My case is, as your lordship has pointed out, that is my case, one aspect of the matter. But when it comes to selection in promotion, the IFR will rule. The question of the disease reflecting any other tentative seniority or whatever you call it, work charge. Once it is by a selection process, it's a promotion.
But you were promoted only to work charge post only.
My lord, whatever it is, nomenclature. Can it override IFR? No. So, as your lordship has pointed out, Nomenclature is important, but the order is very clear. By departmental selection board. In the word itself is clear promotion. If I will prevail, not some notification or other.
Your case is mainly for grant of family pension, and
My
for
lord.
that purpose, regularization is required.
My lord, otherwise also without that also your lordship can give an order to that effect. For that matter, I may be allowed to draw your lordship attention to extraordinary pension.
Yes.
Rule 2. Where does it apply? Extraordinary pension. Rule 2. Without going through all other nitty-gritty, Rule 2 is very clear. This rule shall apply to all persons paid from civil statement other than those Workmen Compensation Act, which is not applicable in the present case. I may be allowed to read, my lord.
Yes, these rules.
Rule 2, these rules shall apply to all persons paid from civil statement other than those to whom Workmen Compensation Act 1923 applies. Then, what are the nature? Whether their appointment is permanent or temporary or under scale up pay, in the present case, scale up pay, or fixed pay, or piecework rates who are under the rule making control of the governor. So without going through all that, whether somebody was a work charge or permanent or regular, that's not the issue. The rule is very clear that even if it is fixed pay or base work rates.
Under what circumstances extraordinary pension may be granted?
Well, the person who died, if I may be allowed to take your lordship too. Rule 10. Rule 3. For the purpose of this rule, unless there is anything repugnant in the subject or context, accident means a sudden and unavoidable mishap. Mishap due to an act of devotion to duty in an emergency arising otherwise done by violence out of in the course of service. Date of injury indeed is same in the present case. Date of injury means
No. Where is the provision which entitles you to get extraordinary pension? Which provision of the said rules?
I may be allowed to take your lordship to schedule 2. Schedule 2. For determining the compensation payable for death or disability under different circumstances. The cases are categorized in 5 distinct categories as under. A, death or disability due to natural causes, not attributable, that is not applicable in the present case. B, death or disability due to causes which are accepted as attributable to or aggravated by government service. This is contracted because of continued exposure to hostile work environment subject to extreme weather condition or occupational hazard, resulting in death or disability would be example. Then
C is applicable.
C is relevant. Death or disability due to accident in the performance of duties, Malo. Some examples are accident while traveling on duty in government vehicle in or public transport. A journey on duty is performed by service aircraft, missile, sea, electrocution, Malo, while on duty. Then, Malo, C, quantum is numeral 1, family pension for category B in C. Distinction between widows without children or those with children for determination of the quantum of extraordinary family, Malo. Pension stand abolished. The quantum of monthly extraordinary family pension for all categories of widows shall be. This is.
Yes, please continue. Continue.
This is important for the reason that your lordship is clear about EOB rule 2. About even if somebody is in a piece work or fixed pay, then it is this category is given here, my lord. A, where the deceased government servant was not holding a pensionable post. Take it that I'm not holding a pensionable post. In that case, it will be 40% of basic pay subject to a minimum of such and such. Then B, where the deceased government servant was holding a pensionable post, 60% of basic pay subject to
What
a
is the
minimum of
pension?
such.
What is the pensionable post?
My lord, that is what I'm trying to see. The EOB rules is clear that it can be appointment can be permanent, temporary. So when it is temporary or permanent, that is pensionable post. On the scale of pay or fixed pay. It can be fixed pay also. Or base work rates. So that may not be the pensionable post. Even then, the rule is clear that 40%.
Yes.
So in the present case, it is not the question of project. The nomenclature in the FR will go by FR, not by a nomenclature. When it is a departmental selection board, whatever be the name, FIR is clear that when it is a promotion, it is to be taken as permanent in government. And as your lordship has pointed out clearly that in the additional, from the additional affidavit, it is clear that when the disease was alive, because of showing our wrong date of appointment, everything is change.
Where that date has been shown?
My lord,
Which-
it must be because of the,
No, in which document? You have referred to that
my
document.
lord, page 21 of the
Additional affidavit.
filed by the respondents,
Okay.
page 21,
At serial number 989,
989, yes,
39/2000.
39. That is my annexure 2 of the petition.
No, in their reply, in their affidavit in opposition,
Yes.
they have mentioned that you do not fall in any of the category.
My
Two office memorandum within
But they
the.
are not denying about the promotion. District departmental selection board. They have not denied that. Affidavit in opposition. Your affidavit in opposition, my lord. Paragraph 4. What they are trying to see, they have not replied. First one is the small affidavit in opposition, my lord. File on 2510 of 18, my lord.
Yes.
2510 of 18.
In that which para they are referring
They
to?
are saying my assertion is para 2. Departmental Selection Board. That is my statement in para 2.
No, in their affidavit in opposition.
Para 4. That with regard to statements in para 2 of the writ petition, the deponent admits the same only to the extent formed by official report. So writ petition annexure 2 is your official record, not the creation of the petition. The tribunal humbly states that the deceased work charge, including not being being regularized prior to his death, was not a government servant at the time of his death. That is what they are trying to project. As per the service scope of the deceased employee writ petition, the tentative seniority list work charge staff as on 1/4/2008, the date of birth of deceased employee stated 16/11/73 in the date of his joining in service as work charge Bali dated 03/09/2000.
And where is that is in para 4 in additional affidavit, they say that since you have joined on 3/9/2000, therefore you are not entitled to get.
That is what they are saying.
And where is your original appointment order of
My lord,
85?
Page 1, annexure 1. My writ petition. November, page 11, my lord.
Page 11 of writ petition.
My lord, annexure 1.
They have not taken into consideration this document.
No. This is 29 November 1985. Type copy is 11A, my lord. In the entries of work, Sri such and such is hereby appointed as work charge fixed Jokali. So it was a fixed day of rupees such and such from the date of his joining under.
But in your service book, your date of joining has been shown as.
My lord, the service book is created by the office, not by the petitioner, my lord.
Okay.
He might have overridden something that is for which the petitioner cannot be taken
So
into
they have
task.
not taken into consideration the office order dated 29 November 1985.
My lord, that is what I'm trying to see. Then this, I may be allowed to continue. Date of joining under the STO number 2 Tuinsang with headquarters at Tuinsang. This appointment, my lord, the appointment itself may be seen, is made against Mr. Such and Such. Chukali, whose resignation is accepted by this such and such with effect from 16/11/85. So the appointment itself is against a resignation vacancy.
Why the division bench set aside the
My lord,
single bench order?
we have stated that it will be considered under 2004 regularization of work charge in 2015. So fine, you consider it as per that.
No, there was a direction by single judge to consider the regularization and grant of family pension.
My lord.
And ex gratia. Ex gratia was reviewed by the single judge.
My lord.
In between 1 to 5 lakhs, discretion was given to government. Then government went on appeal. You also preferred an appeal.
My lord.
In that appeal, that single judge judgment was set aside. The direction for regularization as well as grant of pension was also set aside. What was the reason?
My lord, the submission of the government before the division bench that
No,
will
no.
be considered.
No, what reason was shown by the division bench
My lord,
for setting aside the single bench? What wrong was found in the single bench order?
page 19,
Of the,
para 19.
Para 19 of,
My lord,
of the writ petition page.
of the division bench order.
Where it is? In
Page 5-6.
of the writ petition.
Yes.
Yes.
In view of the above reason, the impugned judgment in order such and such, order dated such and such are not sustainable in our accordingly set aside. However, in view of the submission made by the learned senior additional advocate general that the cases of the deceased work charge employee will be considered for posthumous regularization, we direct the respondent, state the respondent to consider the case of the deceased work charge employees in all the 3 writ petitions for regularization. 1D prior to their date along with other eligible candidates. For the relevant period of time in terms of OIN 2004. In as amended from time to time.
What was there in 22/9/2004 AM? What was the criteria?
My lord, that is reflected in
the rejection order.
Para 15, my lord, page 53.
Page 53 of.
Yes. May I read out?
Yes.
With regard to the direction passed by the learned single judge to regularize the services of the deceased work charge employee posthumously for the purpose of pensioning pensionary benefit, we are of the view that the direction did not take into consideration the eligibility criteria required in the scheme for regularization made by the state government as per OEM 2004.
What was the eligibility criteria?
My lord, 50% of the vacancy in a year should be given to the work charge employees. My lord, as your lordship has pointed out, the question about the EUP, extraordinary pension. Even in the present writ petition, your lordship will consider that. That is the rule. Just see that the present petitioner have no other case, not senior, take it 2000, or any other subsequent day.
Then what should be the consideration for grant of UP? Rule 10. What the Schedule 2 is okay.
2C.
Now 2C lays down the eligibility, that under what circumstances in all cases of premature death, whether extraordinary pension.
No, if it is by natural causes.
In all cases of death falling within A, B.
A will be as per 1972 rules.
Okay.
So
B
unless
and
somebody
C.
have completed certain period of time.
Schedule 2 B and C.
C will be applicable in the present case. But A, by natural causes, it will be as per 1972 rules.
So requirement is when a government servant is considered as due, when death of a government servant is considered as due to government service in terms of Rule 3A, his widow's.
Rule 3.
You are claiming extraordinary pension in terms of Rule 10, read with Rule 2, read with Schedule 2C.
My lord. In 3A, my lord. 3A1. Disablement shall be accepted as due to government service, provided that it is certified that it is due to own injury or disease, which is attributable to government service or
Government has not contested that you died due to it.
I may be allowed to increase on that. Rule 3A1, small b. Small b.
3A1.
3A1, bracket B.
B, yes.
Yes, they shall be accepted as due to government service, provided that it is certified that it was due to or hastened by a own injury or disease which was attributable to government service. Aggravation by government service.
Government has not contested that you died due to electrocution.
No, it is.
That is not contested.
No.
That is admitted.
They are not.
That you died on your husband died on 16/2/2010.
Yes. In,
That is not contested
no,
by the.
no,
Okay.
we are very clear in that line.
So your case is that otherwise also you are entitled to extraordinary pension.
Family.
Extraordinary family pension, family
yes.
pension.
Yes.
In terms of Rule 10, read with Schedule 2C, as well as Rule 2.
Yes. Rule 2
It
will be the beginning. Just see that I think that I am a fixed pay employee also.
Still also you are entitled to get.
Yes, my lord, that is what I am trying to say.
Okay.
And my lord, as my in the earlier proceeding, what happened is the government tried to project that the EOB is not applicable to state of Nagaland, which is not the case. I'll try to take your lordship to my additional affidavit in reply.
Page number?
Page 228, Annexure 136, madam. This is I may be allowed to explain.
228.
228.
Yes. What is this?
This is Government of Nagaland Finance Department, 7 March 2001.
Yes.
These 72 rules is applicable in the state of Nagaland. 1972 rules. As what is EOB? It's a part of 1972 rules. Then page 229, my lord. This is the Government of Nagaland publication. 17.8. EOB has been liberalized timing. 2nd August 2002. Liberalized pensionary award in the case of death in liability, disability incident.
Where are you reading? Page 229.
Yes. 17.8. The bottom.
17 point. Yes, 17.8.
Yes. Subject liberalized pensionary award in the case of death in disability in certain circumstances and special benefit in cases of death in disability in service. Payment of ex gratia, lump sum compensation to families of government civilian employees. Then this is Government of Nagaland. The undersigned is directed, madam, to include a copy of letter dated 12/7/2002 received from the Department of Personnel in Training for information. So it is implemented, circulated. Then 12th July 2002, what does it speak? To the Chief Secretary's mother. all the state government in Union Territory. Here, I'm directed to refer to the department letters as in such and the subject cited above in the Department of Pension and Pension Welfare OEM dated 9 April of 1990 and OEM number such and such of 11 September 1998. Both the copies includes have issued order for liberalized pensionary award in the case of death and disability as a result of attack by or during action against extremist anti-social elements, enemy action in international war of borders, skirmishes, and payment of special benefit to of ex gratia lump sum compensation in case of death in certain cases as mentioned in the aforesaid order of the Department of BW. These orders are issued by the aforesaid department in respect of central civilian government servant as the measure of welfare scheme in certain circumstances. Keeping in view the working condition of the members of all India services, it is felt that these officers are exposed to the same amount of risk while performing their official duties. The question of extending the aforesaid scheme of the members of all India services has been examined in this department in consultation with my lord, not by the central government only, in consultation with state government. And it has been decided that the provision of the aforesaid two memoranda issued by the Department of Science will be equally applicable to the members of all India services modalities from the date these are applicable to the central civil government servant irrespective of their place of posting. Then this is circulating 1990 as well as 1998. Then, my lord, in my written submission, I've includes this portion. In my written submission, page 11, my lord. So, this is the continuation of the compendium published by the government of Nagaland. All this anecdotal. One is a decided case which I've annexed as Annexure 9 to the my affidavit in reply. That is a decided case, my lord. Family, extraordinary family pension. In this particular case, the person was a fixed fee.
No, their submission, what is your response to this? The stand taken by the government side that extraordinary pension rules is not applicable to state of Nagaland.
My lord, that is what they have submitted in the earlier proceeding. That is why I'm trying to make that point. This what I'm particularly before you note is about the liberalized pension.
Yes.
Which is Extraordinary pension has been liberalized time and again. In this case, in 1998, 1990, as well as in 1998. Para 3, Governor Nakalan, the one which I am submitting, in year 2nd August 2002, has clearly provided for liberalized pensionary award in the case of death in disability.
No, this liberalized pension.
Yes.
Which the government of Nagaland is mentioning in its OMs.
Yes.
Is it extraordinary according to extraordinary pension?
Well, here what are the criteria it is given here? In their own company. That is what I'm trying to say.
But they have not categorically stated that these extraordinary pension rules would be applicable in Nagaland.
My lord, since there is a ruling in that time already.
The judicial order is there.
Yes, which is annexure 9 to my affidavit in reply.
Page?
Page 5.
Page?
Page 5. Affidavit in reply. File on 12/3/2019.
12/3/2019.
Yes.
There are so many.
Yeah, okay, if I read out, since it's a short document.
Yes. In your affidavit in reply dated 12/3/19.
19.
And
yes. Start page 5.
Page 5.
Yes.
Yes.
Page 6. Heard Mr. Sarizat. Heard also Sarizat. Appearing for the respondent Sarizat. This writ petition para 2 has been filed by the widow of the deceased government servant. As stated in the petition, the petitioner husband was initially appointed as something wrong. Okay. As stenographer, if I'm not mistaken. Okay. Wait. Yes, one of the this very
No, what was held in this case?
Malota. In view, in view of the aforesaid submission made by the learned counsel for the parties in as agreed upon by them, this petition is disposed of by directing the state, particularly 2 and 3, to finalize the payment of ex gratia to the petitioner as expeditiously as possible within 3 months from the date of receipt of this order. The aforesaid respondent shall also consider in past necessary order in regard to payment of EOP, extraordinary pension, as per the entitlement and as per the provision under EOP rules. So that is the position. Or this court is concerned.
That was in That case, a direction was given,
Yes, and that is
but no finding was given that EOP rules are applicable to.
applicable, not applicable is not nothing else. But the rule itself is very clear. Then I may be allowed to continue with that batch 11 September batch 235 of the additional EIR. This is special benefit in cases of death and disability in service, payment of ex gratia lump sum, compensating the family, government civilian employee who die in harness, recommendation of the Fifth Central CBC.
That is in respect of families of central government civilian employees.
My lord, this is the publication by the government of Nagaland.
No, maybe, but it is for the central government employees, not.
My lord, that is what I'm trying to see. This is a continuation of batch 229, which has been includes by the BNER, my lord. Am I clear to you?
Yes.
This is understanding is directed to include here with copy of service action received from the BNER personnel in training for information, that is a circulation by the
No,
government of Nagaland.
not for implementation.
No, my lord, I may be allowed to take to your lordship to the next page. This is from the ministry. This is not the repeat. This is to chief secretaries all the
Yes, but
states.
that also pertains to family of central government employees only.
My lord, what I'm trying to see is this. This has to be implemented in all the states. Because this is to
Yes,
all the
in
chief
all the states, but only in respect of compensation to.
The central government employees doesn't come under the state government. You will take care of themselves. So this is what the decision of the ministry to all the chief secretaries without giving any option to adopt or not to adopt. As your lordship has pointed out clearly, as far as the all India services, yes. This is directed to all the states. And it is been published in the government company.
Yes.
So here also it is like that yes, schedule C. In the second schedule C of the EOP, extraordinary pension rules. Fine. Now it's clear. 235, my lord. This is 11 September 1998. Page 235 of them. Additional EIR. This is Department of Personal.
This is for-
of the government of Nepal.
But for central government civil employees.
Malone, that is what I'm trying to see. Malone. All these happen implemented by the ministry in all India level. Accordingly, it's studied for implementation in all the state. As your lordship has pointed out, that if it is asked for the central government employees, the state do not control that. So all the department wise, we are covered by the ministry decision, which was directed to all the states by page 230. Anyway, page 236, it is exactly like in the extraordinary pension rules. A, B, C, D. This is the consolidated OEM. If I may be allowed to read out, 235.
Yes. Yes.
OEM, special benefit in cases of death in disability in service, payment of extra lump sum compensation to families of central government civilian employees who died in harness, recommendation of the fifth CPC.
It relates.
All this easy happen adopted. The government of Nepal also follows the CPC. So it is as per the fifth CPC. So under what circumstances, as your lordship has pointed out, central government civilian employees paid from civil payment other than those to whom Workplace Compensation Act applies. That is exactly as it is EOB.
Yes. No,
Yes. Yes.
It is similar to EOP Schedule 2. The Rule 2,
yes,
as well as
yes. Then I may be allowed to continue for your lordship.
Yes.
Who sustain contracted disease or die or disabled of incapacitated on account of causes which are accepted as attributable to or aggravated by the government service are eligible for certain special benefit under CCS extraordinary pension rules. So it is liberalization. It's a continuation of extraordinary pension rules. The benefit available under the rules have been amended and liberalized from time to time. That is what it is 98. Separate orders have also been issued by government to provide for grant of liberalized pensionary awards in cases of death or disability arising in certain special circumstances, such as one, attack by or during action against extremist, anti-social elements, enemy action, international war or border risk, premises. So in the earlier, it was only in case of attack or action against extremists in anti-social elements. When enemy action in international war or borders skirmishes, then page 236, Malo. Earlier, we were issuing department-wise, ministry-wise also. But here, in supportation of all earlier orders issued by the government as well as by individual ministries and departments, insofar as this rule relate to the payment of ex gratia lump sum compensation in certain specified circumstances, the president is placed to decide the family of central government civilian employees who died in the performance of their bona fide official duties under various circumstances shall be paid the following ex gratia lump sum compensation. That is, death occurring due to accident in the course of performance of duties. By this 1998 OM, it is 5 lakhs. Then,
No, Mr. Longchair,
yes,
this OM issued by Government of India is in respect of grant of liberalized pension and ex gratia to the families of central government employees only.
Malo.
How it is applicable to your case?
Malo, that is what I take your lordship to that. When it is a direction from the government, page 230.
Yes.
This is to all the chief secretaries.
Yes.
In how it was circulated by page 229, 12 July 2002, issued by the government of Nagaland, page 229, Malo.
Yes.
This is the understanding is directed. It's a direction. To include here with copy of later dated 12/7/2002, received from Department of Personnel and Training for your information. So all these circulars or OM have been circulated by the government of Nepal. In this 12 July 2002, leader is to all the chief secretaries. It is not a question of you big or choose. In this one speaks specifically about 9 April 1990 and 11 September 1998, which is includes along with this office leader to all the chief secretaries. Accordingly, it was published in the Nagaland government publication. The chapter 17, Malo, I may be allowed to. This volume is not with me. There are 2 volumes. This volume is
No, Mr. Longchair.
yes.
Assuming that it is published in Nagaland governments, but still it remains a benefit to be given to family members of the central government employees.
Malo,
My
no.
query is how it will be applicable to
Yes,
state
that is
government.
what I'm exactly coming to, Malo. When it is central service employees, the department wise, wherever they are, it is covered. In Nagaland also, there are central offices. So they are covered by the ministry OEM. Now, what happened is the direction is given to all the chief secretaries. It is not the all India services.
No,
person.
because central government employees are also functioning in some state government departments.
Malo, I understand that.
It is for their benefit.
Malo, what I'm trying to say is that when OEM issued by the central government, published by the state government, that covers all the employees because the CPC, this is on the basis of fit pay commission.
No.
In your Nagaland also is following that fit pay commission.
But there is, you have failed to show any circular or notification or any document which says that this would be applicable to state government employees also.
My God, that is what I'm trying to say.
Trying but not
Not
not succeeding.
What I'm trying to see is government
Yes.
by 2nd August 2002, page 229.
Yes.
Subject is liberalized pensionary award.
No, I have understood that. It has circulated it for information to all departments.
Yes.
But the circular, but the government letter which was circulated relates only to benefits to be given to central government employees. Though it has circulated, nowhere it has been mentioned that same is to be.
A certain OEM is circulated by the particular government.
Mere circulation is not enough. What is the content of that OM? That would be applicable.
My lord, that is why that OM is circulated by the ministry to all the chief secretaries. That is page 230.
Okay.
Yes. If of course, my lord, what your lordship is pointing out, I understand. Because the government of Nagaland have not given the notification.
Yes.
Saying that this is out of no.
Yes. Yes.
It may be there, but I'm ignorant now. But I'm very clear that these leader circulated in 1990, in 1998 is a direction to all the chiefs. In this has been issued by the government. Page 229.
Yes.
Yes. That is what I can. That much I can.
That is okay.
Yes, that much.
Okay.
I can see that much.
Is anything else?
Sufficient.
Okay. Now,
Much of what?
we have taken up only one case.
Malo.
Other two cases.
Malo, in the facts of the case, I've given one. Then.
No, in case of in all
Yes.
three cases are cases of electrocution.
Yes.
On same day.
No.
On different dates. Different dates.
Division
So
of-
facts you have mentioned in your written submission.
Yes.
And the seniority list.
As far as this.
Because facts.
Affidavit you file only in the case of
Then we will dispose of 69 only. We will hear 69 only. Because
That'll be sufficient, my lord. Yes.
70 will detach from this group.
My lord.
Otherwise, it will take again a very long.
I understand your lordship, my lord.
So we are hearing 69.
My lord, whatever decision taken in 69 will cover the
70 and 71.
subsequent writ petition.
But facts are different.
Yes, facts are different.
Yes.
So it will take time to go through the facts.
Yes.
Much obliged.
Yes, Mr. Fong.
May I please, lordship. My lord, I won't take much time. I'll try to submit my submission precisely, my lord. Before I go into the merits, my lord, first, I want to make my submission that this instant petition can be dismissed on the ground of delay in laches, my lord.
Delay in laches.
Yes, my lord, because lordship may kindly see that petitioner husband was died on 16/2/2010, and the writ petition was filed on 31/5/2016.
When he died 16?
16/2/2010.
And this writ petition
was filed on 31/5/2016.
But before that, they have approached.
This is the previous writ petition. There is a continuity. Yes, there is a continuity. So this is the writ petition filed on.
No, but the previous writ petition was allowed.
Filed on 31/5/2016.
31/5/2016.
Yes, yes.
But that was not dismissed on the ground of laches and delay.
However,
rather, it was allowed.
Yes, my lord.
So
And that is my first ground, since there is a delay of 5 years and 3 months.
In filing the earlier petition?
Yes, my
Or
lord.
this petition?
Yes, yes, my lord.
We are concerned about this petition only.
My lord, this is the continuity of the previous writ petition. This is the continuity, my lord.
No, but in subsequent writ petition, can you take the plea that the earlier writ petition which was allowed was barred by delay in laches?
Yes.
Okay, okay.
Secondly, my lord, the petitioner is submitting beyond the pleadings, my lord. In the writ petition, your lordship may kindly see in the writ petition, nowhere in the writ petition, the petitioner is praying for extraordinary pension, my lord. Here, the petitioner is only praying for posthumous regularization for pensionary benefits, not extraordinary pension, my lord. Even in the prayer also, your lordship may kindly see the prayer of the writ petition, my lord.
Okay.
Yes. So that is my second ground, my lord. And in regard to my facts, in the facts, my lord, judgment and order passed in writ appeal number 24, writ petition on 24/11/2017, my lord. That is annex at page number 40, annexure 7 of the writ petition, my lord. Writ petition, page number 48. Annexure 7. Annexure 7, my lord.
Yes.
My lord, here what I want to submit is, my lord, in this writ petition, in this writ appeal, whatever submission made by the writ petitioner has been discussed and already decided, my lord. Already decided, my lord. Your lordship may kindly allow me to read para 16 of the judgment.
Para 16?
Yes, my lord.
Yes.
Merit, my lord.
Yes, please.
A perusal of condition number 3, 4, and 5 clearly shows that the regularization of workers' employees would depend upon the vacancies
that occurred in a year and that regularization would be done on the basis of seniority cum merit. A perusal of the writ petition and the affidavit in opposition filed by the state government shows that no averments have been made by either of the parties that there were vacancies that occurred in a particular year or that the deceased person were the senior most work charge employee in the department who had a right to be considered for regularization. As per the OM dated 22/9/2024, 204, accordingly, the positive direction passed by the learned single judge in all the three writ petitions to regularize the three deceased work charge employees posthumously may affect work charge employees who are still serving and who may have been more senior than the deceased person at the time of their deaths. These in turn could lead to multiplicity of legal proceedings. The right to be considered for regularization would only arise if there are vacancies within the quota reserved for regularization and also on the seniority position of the deceased work charge employee with other work charge employees. Para 19. Para 19. May I read, my lord?
Yes.
In view of the above reason, the impugned judgment and order dated 9/5/2017 passed in WBC number so and so are not sustainable and are accordingly set aside. However, in view of the submission made by the learner senior additional AG that the case of the deceased work charge employees would be considered for posthumous regularization, we direct the state respondent to consider the case of the deceased work charge employees in all the three writ petitions for regularization 1 day prior to their death, along with other eligible candidates for relevant period of time in terms of Office Memorandum dated 22/9/2004 as amended from time to time. These will, of course, be subject to the availability of regular vacancies during the lifetime of the deceased work charge employees, and in the event of regularization, all the entitlements regarding pension and other pensioner benefits will be paid to the petitioner, great petitioner. My lord, here in the last line, these points may be noted. These will, of course, be subject to the availability of regular employees, regular vacancies during the lifetime of the deceased work charge employees. So, my lord, in the writ appeal, direction has been given to the state respondent to consider the petitioner case in accordance with the Office Memorandum 2004. So, as per the 2004, your lordship will kindly see the Office Memorandum 2004.
The judgment also mentions about that.
In the judgment,
para 15.
Yes, here in para relevant para is at clause 4. Work charge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that senior most work charge employees in the relevant category will be regularized subject to his or her fitness for the vacancy post. So, my lord, the Honorable Division Bench has given direction to consider the petitioner case on the basis of 2004 OM prior to one day prior to the death of the petitioner's husband. So, subject to availability of regularization. So, in the 2004, it says that seniority cum merit. The seniority will be given the privilege. So, in the seniority release,
in the seniority list, your lordship may kindly see the he is his seniority list stood at cell number 989.
But
At
there
that
you
point of
have
time.
shown the date of appointment as 18/7/2000. No, date of appointment as 18/3/9/2000.
No, my lord, that is the, I'll come to that point. I'll clarify that one, my lord. This is the seniority position, my lord, in the.
He's disputing this seniority position. The petitioner is saying that his date was wrongly shown as, the date of promotion was shown as date of appointment in that seniority list.
So, I'll clarify, my lord, in that regard. My lord, in the impugned letter enclosed in the writ petition.
Well,
In the writ petition, the last page, page number 57. Here the government has referred to OM. 57, page number. Annexer 8.
yeah.
My lord, in the state of Nagaland, for regularization of workers employees are considered under these two OM. One is Office Memorandum dated 22/9/2004, and the other is Office Memorandum dated 17/3/2015. 2004 is in regard to it is considered on the basis of seniority come merit, and 2015 it is
50 years.
considered that those work-charge employees who have completed 30 years and enjoying scale of pay. Here in the case of the petitioner, though the petitioner is getting scale of pay, but he has completed only 24 years. That is why Office Memorandum 2015 is not applicable. He's not covered by 2015. 17 March 2015 is not applicable. So his case is covered under 22/9/2004. That is, case will be
50%.
considered on the basis of seniority come merit. Your lordship may kindly see my affidavit in opposition. Your lordship may kindly see my affidavit in opposition, filed by respondent number 1 to 8. Dated 25/10/2018.
Yes.
Para 6. Your lordship may kindly allow me to read para 6, my lord.
Yes, please.
That with regard to the averments made in paragraph 7 of the writ petition, the deponent humbly, while admitting all statements which are derived from records back to state that the core ingredients required to be addressed by the state respondent as per the actions of a common order dated 24/11/2017 passed in writ appeal numbers and so on. By division page of the Honorable Gauhati High Court are extracted and produced as under. Number 1, the state respondents to consider the case of the deceased work charge employees in all the 3 writ petitions for regularization 1 day prior to the death, along with other eligible candidates for the relevant period of time, in terms of Office Memorandum dated 22/9/2004, as amended from time to time. These will, of course, be subject to the availability of regular vacancies during the lifetime of the deceased employees.
As regard the allegation leveled by the petitioner, the deponent respectfully states that in compliance with this honorable court order dated 24/11/2017, the department has considered the case of the petitioner's husband, late Wang To Chang, workers Chukali, with the findings that as per the tentative seniority list as on 01/04/2008, his name appears at serial number 989. And as per records, his seniority possession stand at serial number 811 as on 15/2/2010. The deponents beg to state that as regard to workers' employees, the process of regularization is done as per the seniority list but subject to availability of regular or sanctioned vacancies. However, the seniority possession of the deceased employees as a workers' employees comes nowhere near the zone for regularization. Reason being, as per OM dated 22/9/2004, issued by the Personnel and Administrative Reforms Department of Nagaland. Workers' employees will have the right to be considered first for regularization against the 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such will be considered on the basis of seniority cum merit. This means that the senior-most workers employee in the relevant category will be considered subject to his or her fitness for the vacant post. In order to accommodate the petitioner's husband for his service regularization under the aforesaid scheme on the basis of tentative seniority list as 15/2/2010, there must be at least 1,622 regular vacancies of similar nature in the department before the day of his expiry. However, this had not been the vacancy situation with the department at the relevant point of time. Again, as per the amendment, OM dated 15/3/23. This is in regard to completion of 30 years. The last para, such have been the circumstances that the case of the petitioner husband does not come under the purview of either the or the amendment dated 17/3/2015, even for posthumous regularization for pension and pensionary benefit as per the direction dated 24/11/2017 of this honorable court. Accordingly, by the impugned order, later dated 31/2018, the department has informed the petitioner about the rejection of prayer for posthumous regularization of the service of her late husband. And your lordship may kindly allow me to refer rejoinder affidavit. Rejoinder affidavit.
By your additional affidavit.
Yes, rejoinder affidavit.
We filed
Page on
one affidavit in opposition in as per this honorable court direction, additional affidavit in opposition. When I filed a reply to the additional, we filed a rejoinder affidavit.
Filed on 5/8/2024.
5/8.
Filed on
5/8/2024.
Gender affidavit. That is on 7/8. Yes, on behalf of one page. Yes, I got it.
Yes. I'm relying on para 2, 3, and 4.
Yes. Yes, please.
My lord, the petitioner has submitted that the petitioner has been granted promotion and the promotion And thereafter, the petitioner is submitting that some of his juniors have been regularized during the lifetime of the petitioner. So in this regard, I want to refer para 2, 3, and 4. Para 2. That with regard to the statement made in para 2.2 and 2.3 of the additional affidavit in reply, the answering deponent humbly beg to state that the department selection board should be read as department interview board. Initially, the workers employees of the department were appointed on fixed labor for next 2 years and as skilled labor for 2 years or more years. Thereafter, the department interview board, after conducting an interview, they were awarded or granted scale of pay under ROB 1993, whereas during 1980s, the department inadvertently was using the word promotion instead of awarded, as per the instruction issued by the superintendent Interim wide number so and so, dated 5/4/1993, in reference to CES office number dated 14 so and so, was enforcing the same even at the time of awarding scale of pay to the petitioner, led Wang Do Chang by the office memorandum dated 27/9/2000. Though the word used in the aforementioned office memorandum subject as promotion from work charge Mozart to work charge Chukale, it is clearly mentioned in para 3 quote, the scale pay offered does not confer any right upon the government servant mentioned in annexure to claim regular appointment under the Department of Power. Unquote. It is also evident from Annexure 1 of the office memorandum where it mentioned that the list of qualified fixed pay Chukali Mozart awarded to the work charge scale pay Chukali. Therefore, the word promotion should be construed as awarded. Hence, an inadvertent usage of a certain terminology does not materially change the status of being work charge. So the inadvertently they have used the promotion. So there is an office memorandum justifying that it should be read as awarded. That para 3. That in regard to the statements also, the answering deponent pertinent to mention herein that the petitioner has misconstrued and misunderstood the department had maintained the tentative seniority list of workers employed as per merit cum seniority from the date of awarding of scale pay to the workers employees. The date of joining in service is counted only from the effective date of awarding scale of pay. As such, the question of arbitrary date does not arise. Before the expiry of the petitioner led Wang Do Chang, his real number stood at 989 as per the tentative seniority list of 014/2008. As such, if had been alive, he would have been regularized much earlier than Sri numbers on Sri Iminansi, whose serial number stood at 1204. The department maintains two separate tentative seniority lists of work charge employees, that is, electrical trade and civil wing. Therefore, with regard to the tentative seniority list of work charge as on November 2021, as reflected in serial number 1, Sri Nyomnye is work charge Chukali under civil wing and does not fall under electrical trade. Most of the work charge employees whose name was recorded in tentative seniority list of work charge as on 01/04/2008 over the years have been regularized or some have expired. As such, tentative seniority list of November 2021, it relates to only those existing work charge employees, but the name of those who have been regularized or have expired are not included in the present tentative list of work charge. The seniority list of the regular employees of the department is maintained separately. It may be stated that there is no provision for posthumous regularization, therefore, in absence of policy or source of law, the state respondents are helpless to consider the petitioner's case. In similarly cases, the request for posthumous regularization in respect of that was dismissed by the Honorable Supreme Court. judgment dated 11/07/2022. Since your lordship it says that in regard to the delay and laches, I'm not pressing on that. That is why I'm not relying this judgment. But my lord, in the petitioner has alleged that in the additional affidavit, in reply, here your lordship may kindly see the annexure 11, page number 61.
Yeah.
Page number 61.
Yes.
In so and so against the system vacancy division with effect from 15 January 2009. This order was issued after the expiry of the petitioner. So all the regularization which was enclosed by the petitioner, they were all regularized after the expiry of the petitioner. And the petitioner is alleging that now the petitioner is alleging that some of his juniors have been regularized.
Serial number 70 to 124.
Yes, my lord. Then when they were considering when they were regularized, what the petitioner were doing, we were never approached the court challenging their regularization. Now only after a gap of so many years they are facing this issue, my lord. And
this regularization order of annexed at annexure 11, was it issued before the death of?
Yes, my lord.
On 15.
And my lord, in the annexure, there is handwriting that there is handwriting in the right side column, date of appointment.
Yes.
Yes, this is not the date of appointment. It should be date of joining. That is the date of granting of scale of payment. And para 4, my lord. Kindly allow me to read para 4.
Yes. Of your rejoinder.
Yes, my lord.
Yes.
That in regard to the statement made in para 5 and 6 of the additional affidavit in reply, the answering deponent humbly beg to state that no juniors have been regularized before the demise of the petitioner husband. Everything was done as per seniority list and in accordance with the laid down procedure. It is a settled principle of law that if someone delays in pursuing a legal claim, they may be barred from seeking relief or remedies. Herein, the petitioner has approached the court after a delay of, my lord, it should be 5 years, not 8 years. There is timing mistake. Before an instant case is liable to be dismissed on the ground of delay and laches. Moreover, without impleading or making a party, the petitioner cannot question the legality of the regularization order of those who were regularized after the death of petitioner's husband. My lord, may kindly allow me to refer additional affidavit. Is filed on 27 April 2020.
Filed
by the state respondents.
Yes.
This affidavit was filed in compliance of Honorable Court Order dated 9/3/2023 and 11/4/2023. Honorable My lord, honorable court has directed the state respondents to file the seniority list
Yes.
before the death of the petitioner and the seniority list maintained. The latest seniority list. Para 2. Para 2, your lordship, para 2. That by order dated, Honorable Court order dated 9/3/2023 has directed the state respondents to obtain instruction as to how many persons have been regularized in terms of the tentative seniority list Chukali as on 014/2008 and shall also furnish the latest seniority list of workers Chukali and thereafter by the Honorable Court order dated directed the state respondent to file the instruction by way of affidavit. In compliance of the said Honorable Court order, the deponent is filing the instruction received along with the seniority list as follows. The total number of employees regularized in terms of tentative seniority list as on 01/04/2008 is 30. That is serial number 1 to 30. It is also pertinent to mention herein that the petitioner husband led W. Wangdo Workchars Chukali as per the tentative seniority list as on 010. His name appears at serial number 989 and as directed the latest seniority list as on November 2000 is also placed for perusal. So as per the seniority list dated 01/04/2004. His seniority stood at 989. So my lord, here, so my humble submission is, my lord, there is no policy to consider the petitioner case. Only the 2004 OM, but even in the 2004 OM, he is not eligible. Because as per it goes, when it goes.
Whether extraordinary pension rules are applicable.
My lord, in regard to extraordinary pension rule, there is no notification as such that it is applicable in the state of Nagaland. But my lord, here the petitioner is only praying for the posthumous regulation, not praying for extraordinary pension.
Okay.
And the office memorandum, which the petitioner has referred, that it is in regard to the payment of ex gratia only. Payment of ex gratia only, not the extraordinary pension. Extraordinary pension and the ex gratia is different, my lord.
Okay.
So my humble submission is there is no source of law to consider the petitioner's case. So as per the 2004 OM, the petitioner case is not eligible. That is my humble submission, my lord.
We have heard only WPC 69. Item number 31. Heard Mr. No, first we have to detach this. What is? Heard Mr. I.M.T. Longchar, learned counsel for the petitioner. Also heard Mr. E. Tiba Form, London Government Council. Though this writ petition is tagged with other two writ petitions, namely WPC 70/2018 and WPC 71/2018. Due to paucity of time and for the sake of convenience, this writ petition was heard separately, and other two writ petitions are detached from it. Hearing concluded, judgment reserved.
And my lord, N. Moser is appearing for.
Oh, yes,
Response
yes.
number 9.
Council also heard Mr. N. Muse appearing for
Respondent number 9.
respondent number 9.
Accountant General.
Okay. In our other two 33 and 32 and 34, though these two writ petitions were tagged with WPC 69/2018, however, due to paucity of time and due to and for the sake of convenience, same are detached from WPC number 69/2018. Stop. We are fixing this after 2 weeks.
Okay.
Let these writ petition be listed separately after 2 weeks on a date to be fixed by registry.
Much
Multiply.
69, you give it to in chamber.
Ini saja, jadi itu